Yes.
My lords, pray for lunch motion in respect of enlargement of time. Which I argued yesterday, my lords, regarding
Enlargement of time. So which
in
it
respect
is
of
order
amount
passed by
paid
which bench?
towards pre-appeal deposit of DRE.
No.
My lords.
Which bench the order was passed?
My lords.
Order of which
Same
your
bench, my lords. Second bench, it has been now the portfolio is with because it is matter corrected to Surface Act, my lords.
no. No, but it was order. The application for modification will go before the same bench. Which are the two honorable judges which had passed the order?
My lords, the Surface Act is now with this, my lords. DRT, DREAT is allotted to first bench, my lords. Already,
You are getting it, Mister.
my lords.
You meet the registrar. You meet him. He will guide you, Mister. This thing, Reddy. You want to explain him?
The judge has already
One minute.
my lords.
1 minute. This thing, he is filing an application for modification of an order passed by the division bench, right? Yesterday he had filed a petition. We told him that you should file an application for modification. He has filed it. The application for modification has to go before the same judges. So he is not telling us which are the two judges, right? So you tell him. And all right, you please talk to Registrar Judicial. He will explain.
Oh, my lords.
It will be put to me on administrative side.
Sure, my lords.
It's not difficult, right? We are asking the name of two honorable judges which had passed the order. Simple. You are not.
I just see. I understood.
Yes, yes. So the matter, if one of the judges is available, the matter has to go before a bench of which one of the members, one of the judges, if he is serving the High Court, should be a member. So for that, it will come before me. We will pass an order.
Medical admissions.
What?
Registration management for the court matter. What is
All
court
right.
matter?
Yes.
Admission matter, fresh admission matter, my lords, they were numbered but not listed.
Fresh?
May I request tomorrow, my lords?
Huh?
Fresh admission matter, my lords, numbered but not listed. We have filed on 11th this month, my lords.
11? No, what is the matter? What is
sir,
the urgency?
You are challenging the rules of the teacher recruitment test. Response matter, not receiving applications of the petitioners. I request tomorrow, my lords.
Tomorrow?
Oblige.
Yes.
Medical admission matters.
Today? It's a no mention day, right? You people tell us, Mister, and you violate this thing. One of you told us 2 weeks back that no mention can be made at 10:30. He was mentioning at 1:30. And now you people like 10:30, you yourself violate the circular. You are officers of the court, right? There is an order by the then Chief Justice saying that mention can be made only at 1:30 and 2:30. That you should tell in the beginning matter. After the mentions are, I don't remember this practices. I am not accustomed to this. So I don't know. You should tell in the morning that it's a no mention. After I have granted, we have granted to everybody. You are saying no mention date. Your duty to tell us in the beginning that it's a no mention date. I don't remember. You place this order, this modification, 1:30 and 2:30. You place it, we will modify it. It can only be made at 10:30 only. Yes. Yes. Huh? 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 Yes. Which number? 10. It will be called. Don't worry. It will be called. It will reach. It will be called. Yes. Yes.
Lunch motion.
Hey, what lunch? We are taking item number 1 has been called. What is the lunch motion about?
Medical admission.
Give it. You should be on time, mister. This is what, see what time is it? Yes.
Lordship, that I have filed on Friday, it appeal online.
Huh?
Monday I have filed the physical
You have not
copy.
called item number 1. That nobody is appearing. Yes.
But till today they are showing that in the process. Even I have filed the physical copies also in the online. I have filed the writ appeal, your Lordship, on Friday. Till yesterday it was showing on process. In morning also it is showing in process. Physical copies also I have filed, your Lordship. That may be directed to be
Tomorrow,
number.
tomorrow you want?
Tomorrow is the case listed, another matter, connected matter is listed that your lordship.
So tomorrow it will come up.
Oh.
You give the number, what is it? What
I'll
is
give
that
the
SR number? What is
Filing
it?
number I give you, your
Yes,
lordship.
yes. See to it, madam, that it comes up, you tell Registrar Judicial to list it tomorrow. He has gone. Thinking that mentioning is over, the Registrar Judicial has left.
Yes.
Yes, so it's, yes. Yes.
May I please? Madam, the matter arises under the Land Acquisition Act. The awards were passed and the matter was referred to the LARR authority, respond number 3 herein. And agreed by that, the writ petition was filed by the petitioner with regard to the authority while the R5 referring the matter to the authority, but he has not mentioned about the representation given under the by way of a legal notice on 11/1 requesting the Land Acquisition Authority and the R4 District Collector to refer the matter to the LARR Authority. Instead of that, he has only mentioned about the pending writ petition of the filed by the appellant hearing before approaching the sample court. So insofar as the matter arises, the preliminary notification was issued on 8/9/2019, acquiring lands for the Singareni collieries, 624 acres. This is the subject matter is concerned is only with regard to 5 acres and 8 guntas, and another reference was with regard to 14 guntas. Survey number 385 of that Indaram village, Jaipur Mandal in Manchiral district. So now, even
why your petition has been, why the petition has been allowed?
The writ petition was allowed on the ground that in spite of passing award by the Land Acquisition Authority, R5, approved by the R4, instead of paying the amount there, he has referred to, that reference has been questioned by my learned friend by way of writ petition in the, that's how the first respondent has been made party.
That's why it has been.
My respectable submission, and even before the preliminary notification under section 11(1) on 8/9/2019, my client, the appellant hearing, who was the respondent number 6 in the writ petition, has made an representation on 4th January 2019 itself, having come to know that there is a proposal to acquire the land. So that's how he made a representation that he is pending appeals. Insofar as under the statute ROR Act, there were appeals were numbered. Insofar as not only about this particular subject land, the other lands were also there, wherein erroneous entries were made. But for correction of that, he made an appeal. The appeal were numbered, and the report was called for from respondent number 6, the Tahsildar. But he has not sent the report. Meanwhile, the acquisition proceedings were started. So he has made a request on 4/1/2019 itself. Lordship may kindly see at page number 269, page 269, wherein he has very clearly said, unless his appeals are disposed of, you cannot proceed with the land acquisition proceedings. Instead of, and there is also a provision, your lordship very much aware, that even if the after notification also, they are supposed to dispose of the any claims.
No, sir, you are not telling the, coming to the point, this thing, the writ petition has been dismissed on the ground, allowed on the ground that your representation was already rejected on 31/12/2020. You cannot re-agitate
my
the issue.
respectable submission, your lordship may kindly bear with me for a moment. The objection itself is not the finality, my lord. That's how the court has come to a conclusion that it has become final. My lord, that's not the case. Immediately after objection, he has made an application by way of legal notice and also the personal representation on 11/1/2021 itself. to the collector as well as the respondent 4 and 5, RTO, the land acquisition officer, to refer the matter, because even earlier also, on the ground that his claim for the lands which was, appeals were pending, appeals were not taken up, disposed of, even before the land acquisition notification, even subsequent to the acquisition notification, he made an objection. Immediately after the 2019 notification has appeared on the paper, on 5th November itself, he has made a representation objecting that unless you dispose of the appeals pending, statutory appeals were pending before the same land acquisition officer who is also the concerned RDO. Instead of disposing those.
What this order has attained finality, right? 13 and 12. Has not been challenged. What can be done? Yes.
And moreover, your Lordship may kindly see, in this matter also, the order passed by the judge, the only one reference has been questioned in the writ petition. Whereas the order was passed for the other reference also. There were so many references, separate awards were passed for separate extent of lands in same survey number also. So innumerable awards were there. But even after the objections were rejected on 31st December 2021, the award was passed way after so many months. Meanwhile, they could have taken up the simultaneously the appeals also, and not taking into consideration my representation and the legal notice, they have also considered and referred the matter to the land acquisition authority, because it can be decided. Now almost a year back, these matters have been referred to the authority. Within a time frame, Lord may kindly fix the time, and the matters can be disposed of, so that whoever is entitled for compensation, because the entire amount is now deposited in the authority, still it is lying there. Even the morning also I confirmed myself that the still matter, the amount is with the land acquisition authority, the LRR authority. Still it has not been transmitted to the respondent number 5. Now, even the honorable court opined during the course of the argument earlier, before disposal of the writ petition, that the matter can be disposed of there within the reasonable time frame. That could not be done, because subsequently my land friend could not agree for that. The honorable court passed an order. But the other aspects of the matter has been totally not considered by the judge. I am only bringing to the all the materials have been placed before the honorable court, whether from time to time, even prior to notification, subsequent to notification, even after the rejecting my objections also, the writ petition was pending, and it was not considered. Then again, because now the writ petition has become infructuous, he could withdraw, because the award was passed and the matter was referred to the authority, and my client made appearance, and the proceedings were taking place before the LARR authority. Notices were served on both the parties, and I made appearance and filed the
Yes.
filed the claim statements also there, even before I placed the claim statements also before the single judge while before disposal of the matter, and I made all the submission insofar as the right from the 18 onwards, when he made an appeal that was numbered and was now kept pending even as on today also. But apart from the part of the lands which are acquired, the other lands are also there wherein the appeals are still pending. But instead of even during the course of the proceedings also, the appeals can be disposed of. That was not done. And keeping that in mind, that may be the one of the reason that the R5 also referred not only the dependency of the writ petition at that point of time, because the very acquisition was questioned in the writ petition. Lordship may kindly see the acquisition itself was questioned in the writ petition without disposing of the pending statutory appeals before the authority. That's how the matter, once the award is passed, it has become infructuous and no relief can be granted by the honorable court. The only prayer in that is, in spite of objecting for acquisition, they proceeded with the acquisition, And ultimately, award inquiry was conducted and my client was also given notice and he participated in the inquiry. But he could not do proper inquiry and pass a reasonable order. Simply said that your evidence is fragile. But without discussing anything, whether my client is able to present all the revenue records or not, whether they are relevant or not, he has not made any reasonable order in that. He simply said your whatever the evidence produced with by way of revenue records only, because he was the original patedar. That is not disputed. Subsequent to that, my lord, illegally they entered into
What
the.
action have you taken to challenge the order dated 31/12/2020?
But immediately I made a representation to refer to the, under the act, my lordship well aware, I can seek the reference also. But that's how the matter once having come before the authority, during the pendency of the writ petition, I cannot.
Yes, anything else?
The award was passed and it was referred to the authority. I made appearance and fighting out
Hey,
there.
Mister, we are hearing you patiently. That doesn't mean that you should keep on repeating. All other, everybody is waiting.
Yeah, I'm not saying it. That's how the matter
Yeah.
has arisen. I'm only
Ah.
seeking indulgence of the Sound Court to protect the interests of the appellate insofar as his rights
Take
are.
the interest in accordance with law, not
Yes.
otherwise.
Because the statutory appeals are still pending, that could not be decided. But the authority is under the civil procedure, they will proceed with the trial and decide whether they are entitled.
Third time we are asking you the question, what have you done to challenge the order dated 31/12/2020
Because the
by which representation was
The
rejected?
writ petition was pending and it was referred to the authority. Having made appearance, I could not come back and challenge it. Once having referred to, notice is given, made appearance and filed claim petition, I cannot, myself can come before the court and question after the withdrawal of the writ petition. Writ petition was withdrawn on 20th January 2023.
No, this the challenge is only to this order, referring the under section 30th. No, that is different. The challenge in the petition. See, the challenge in this petition is only to order dated referring under 77. I'm clear with this 30th by. We are not concerned about
By the date of withdrawal of the writ petition, already I made appearance and
Where
filing
is the
out.
question of withdrawal of writ petition, Mister? This writ petition has been allowed against which you have filed an appeal. Who has withdrawn the writ petition?
Earlier writ petition was filed by the appellant challenging the very land acquisition proceedings which were pending even before the.
No, so that has come to an end. Now the question is about disbursement of
The
compensation.
Lord has opined that you are not subsequent to the withdrawal of
We
the.
understand, we have read it, Mister.
Yes.
We have decided to conserve our energy, so to speak less. So therefore, please, I mean, don't take it that we are not understanding.
Yeah,
You,
yeah,
the moment we dictate the order, you will be convinced that we have gone through the fight.
With great respect, I am not on that ground. My
No,
point.
this subsequent writ petition is, you know it if you have read it. Otherwise, you read
Yes.
the order
Yes.
which we will pass. Fine. Anything else?
But, so the petitioner, the appellant submissions throughout the proceedings earlier to the land acquisition and subsequent also has been totally ignored and no reasonable order has been passed while discussing the, having conducted inquiry, having issued notice award inquiry. Award inquiry doesn't speak about how, whether my client is having any right or not. It simply says that your evidence produced is fragile evidence. Except that what, that nothing has been discussed. Simply, and the officers also, I made that application also to the collector, wherein the concerned officers who were dealing with this land acquisition matter, there was allegation they were suspended. And the High Court also, Honorable High Court in one of the writ petition also directed to initiate the disciplinary proceeding as against the land acquisition officer, the then land acquisition officer.
It has nothing to do with the validity of the order dated 30th/5/2020.
I'm not on that. I am only bringing to the notice of the court. Such orders, backdoor reports were taken from the Tahsildar and Deputy Tahsildar, and basing on that, he simply ignored the entire evidence, the land records filed before him, and passed the order awarding in favor of the respondent number 1. But insofar as the other reference matter are not challenged before this Honorable Court while filing the writ petition, only one reference was challenged, 5 acres, Ekunda, and the Honorable Court has passed the orders in both the references. Separate references are there, separate OP numbers were given, and the separate notices were issued for proceedings. And in spite of the other 14 guntas were also been clubbed in this reference and passed the order by the learned single judge. On that ground also not the order has considered.
That's it. Anything else? Yes. Heard on.
May I please, Your Honor, beg to appear for addition. See, in this writ appeal, Miller, in this writ appeal, Miller, I am only aggrieved by finding given at para 11 of the judgment. Miller, what happened, Miller? The appellant.
Para 11?
Para 11 of the judgment, at page 21. Miller, the appellant is the owner of the land, Miller, having.
No, but see one thing, Mr. If we can afford to ask you a question, or we will hear you like better. Yes. Yes.
Miller, the appellant purchased the land admitting 5 acres in the year 2005. And Miller, the entire
Party in the rate. What is IU? Please petitioner. Who is he? Please petitioner. How is he concerned with this? This issue pertains to usually that cancellation of this thing, cancellation deed, execution of for registration. Learned single judge is held, it can't be done. Who is he? Ask him, brother. How are you concerned? You are an implead petitioner?
I filed an implead petition, Miller. Appellant purchased 5 acres of land and ultimately title is traceable to 1965 backwards. Miller, my predecessor in title sold the entire land in favor of one other my predecessor of title in the year 1987 and 88 itself. When those persons, my vendor, did not have any title, not even an inch of land, they created a sale deed in the year 1996. After 8 years, in favor of the respondent number 4 herein, who is the respondent number 3 in the writ petition. And he in turn said to have sold that property. I am sorry.
Question is, we are concerned with this release order. So he has to show that how unilaterally cancellation be executed and it can be registered contrary to Supreme. First of all, you are not a party to the writ petition, number one. Secondly, the validity, the order of which you have challenged here is, it pertains to this issue that unilaterally one party executes a cancellation deed and gets it registered. The learned single judge, by placing reliance on decision of Supreme Court, says
Yes.
that it is not permissible.
I am not.
How that is a person who is not a party to the writ petition
Yes,
can
sir.
challenge this order, and what ground it is based on a Supreme Court decision.
Yeah,
So please tell us.
Your Lordship is absolutely correct. And I am not questioning that unilateral cancellation is set aside. No, I am not questioning. When the writ petition was pending, during the pendence of the writ petition, they gave a paper publication touching with my property, attempt to sell. So I went to police.
You file a
Then-
suit, do whatever, seek
No,
injunction if they are selling your.
Then I filed a simple implead petition, Virat, implead petition, 1 of 2019. While dismissing my implead petition along with the judgment, Virat.
Sir, you have a separate cause of action.
Well,
Everything I mean,
Para 11 I will read, Virat, para 11 I humbly submit, Virat, para 11. In so far as claim of IA number 1 of 2019, that is appellant filed implead petition, is basing upon a sale deed said to have been executed by the third respondent in the year 2005, that is subsequent to registration of impugned cancellation deed is concerned. The title over the subject land should transfer to the husband of the petitioner by virtue of
we
registered.
will clarify this that it has nothing to do with right, title or interest of the observation. Parties are granted the liberty. We can't decide this in 226. We will say that.
Here, Virat, they confirm
No.
their title. And
We are
Virat,
saying, Mr. We are to that extent, we will say
Yes.
that it does not contain any observation. You are free to take recourse to the remedy available to
with
you
regard to title of both of the
for seeking title.
with regard to
Correct.
title of the both of the parties.
Correct, Mr.
Both of the parties.
One, correct.
Sought for the cancellation deed for lot is.
That is, so
Taken by that single judge.
we will clarify that it is,
So then they can have it separately.
with regard to right, title or interest. All right.
Interrupt both the parties, Virat, only that.
Withdraw both the parties, what? We will only clarify that the learned single judge has decided the issue of registration of cancellation deed unilaterally and has not expressed, and it is clarified that he has not expressed any opinion with regard to title of any of the parties, free to establish.
DPU, limited clearance.
That's mark the presence with consent of the parties matters heard finally.
Two thousand three, Milad, last. While dictating that cancellation deed dated 2023, it is 2003, Milad.
2003 matter cancelled.
Deeply obliged.
I'm appearing for the appellant. That the writ appeal is filed against the common orders passed in CRPs as well as the writ petition. Against the matter arises under
SLP is pending, right?
yes, status is granted. This is subject to the.
We will defer. I mean, you produced what has happened in SLP.
Milord, page 222, Milord.
Huh?
Page 222, Milord.
No,
222.
so what has happened in SLP? It has been decided.
No, Milord, it's pending. Just
So
admission.
then
only,
we
Milord.
can't
Status
pass
is
any
pending.
order. We can't
Status
pass any
pending.
order. We will keep this appeal pending till adjudication.
Yes, Milord. Page
of
20,
SLP.
223, Milord. Pending, Milord. This is only formal notice is sufficient, Milord. Admission.
223.
Yes, Milord.
Learned senior counsel for the appellant submits that the it will be done.
Obliged.
Ah.
Okay, obliged. Obliged.
May it please your lordships, my lord, I beg to represent Mrs. Jayashree. My lord, this writ appeal is filed, my lord, against orders of the learned single judge.
Yeah,
My lord,
252.
the petition,
Come to para 7C, brother. Para 7, admittedly, now he is saying 252 of Telangana Municipalities Act.
my lord,
Para
252
7 is, Mr. Please see para 7.
my lord, I have gone through para 7, my lord, your lordships are
Ah.
happy.
Admittedly against this thing, now you are saying that no appeal lies.
No, the appeal
Therefore,
is,
you should tell the,
the appeal lies to the regional director who is the commissioner. The order challenge is under the order passed by the commissioner. My lord, therefore, I cannot go to the very same person who passed an order. Lordship may kindly see the impugned order is passed by the commissioner under 252. The regional director, my lord, is the commissioner. It has been defined in the definitions.
regional direction. Where is the order of the day, Commissioner?
My lord, that impugned order, my lord, lordship will get it at page 29. Page 28. Page 28 will lordship will get it. Commissioner Municipal Corporation Karimnagar. Starts at 27.
27.
Starts at 27, ends at 28. It is passed by
Regional Directors Commissioner. Where it is provided that regional director is commissioner.
my lord, definitions. Lordship may kindly, may I request lordship kindly look at the definitions.
Which section? 2.
2, my lord. 275, 74.
Appellate Commissioner of
Regional director means the regional director come appellate commissioner of municipal administration having jurisdiction over the municipality concerned under this act.
Yes, Mr. What do you say?
Under section 252, they have got liberty to file appeal either before commissioner or
Huh?
under 252, they can approach the appellate.
That's what he's arguing. He hasn't understood.
See, the order passed by the commissioner, as municipal commissioner, according to the submissions made by the council, that is referring to definition 274, the regional director himself has passed an order.
This impugned order, page number 28, passed by the commissioner, my lord, in last para, they stated that the
Yeah, but you did not urge this contention. You admitted before learned single judge, Mr., that the appeal lies. You are correct in saying so, but you should have pointed it out before the learned single judge. This contention you are not urged. Correct. We are asking you, counsel for appellant.
My lord, in fact, my lord, I brought to his lordship's notice about the definition of 252, and I said it is only a notice, not even an order. Any notice issued by the municipality appeal lies to the commissioner. And I brought to the notice that his commissioner is
No, it is not a notice, it is an order. Once it directs you to remove encroachment, it's an order.
Now, lordship may kindly see 252.
So what is the ground of challenge that it's not, you are not an encroacher, right?
I'm not an encroacher. And there is no opportunity. A personal inspection has been made, no notice to me. Behind my back, when I report.
So carry out the inspection and then proceed.
Yes, ma'am.
Right, we will set aside this order. There's no point in keeping it pending for 5 years. You carry out the inspection with notice to the appellant and then this thing. We'll set aside this order. There's no point, right?
Till such time,
So then who is the competent authority? We are setting aside the order, Mr.
I'm obliged. I'm obliged.
No, so but who is the competent authority to pass an order? In that sense, if commissioner passes an order, this every case the statutory provision is rendered odious.
Then
Who is the competent authority to pass an order?
a review has been granted to the government under 252(2). A review has been given to the government.
No. You are saying that who is authorized? We are asking you who is authorized to pass an order of removal of encroachment.
But it is by the commissioner only.
Which provision? So then in such a case, I mean, how can this be done? Like,
Initially the notice was given to me.
No. Please tell us who is the competent authority under the this thing act to order removal of encroachment. If the legislature, 1 minute, please understand the query. Which legislature has provided for an appeal according to you to the commissioner, then the very same legislature cannot confer power on commissioner only. That's what we want to see, whether it has conferred. How can enact a provision which is useless? Like anybody will understand that appeal cannot lie to him only.
Yes.
So like this, according to you, 252(1) has no meaning in law because no appeal can be filed if commissioner is authorized. That's why we want to know who is the person who is authorized to remove encroachment.
City planner, town city planner, because he is the one who issued notice to me.
Where is that?
No,
Which provision, Mr.?
No, provision, my lord, I'll take your lordship. Provision is not there. That's exactly the problem. Lordship, page 22 for a moment. Page 22.
No. This thing act, Mr. Telangana Municipalities Act.
My learned friend should be able to tell because.
You should be able to tell. You are the petitioner, appellant.
No, the show cause notice was given to me by assistant town planner, but for which I gave a reply.
How can there be, Mr.?
No, Lordship can take page 22 for a moment.
No. Do you think, I mean, there is a presumption with regard to constitutionality of statutory provision by sheer this thing? If according to you, commissioner is the competent authority, then 152(1) is a useless provision. Law cannot provide for an appeal from the authority to itself. I mean, this is something defies logic. So therefore, we are asking you who is the person.
Lordship, put it to tomorrow, minute. I'll come with the.
Learned counsel for the petitioner submits. Learned counsel for the appellant submits. tomorrow.
Need your money?
Satyavati Tandon.
Permit to give it time to repay the entire loan amounts.
No, we don't know. You pay, you make an application. We are not the authority. We don't run the bank. We don't know. You give a this. You are challenged the order dated 1/7/23, 13/4. Satyavati Tandon appeal application approach DRT.
Sir, party will
Huh?
party will incur heavy loss, sir. We go to a DRT.
Yes. Anything else? No. If we ask,
He's ready to.
no. Supreme Court's 3-judge bench of Supreme Court says that you should file approach DRT. So, is this an answer to 3-judge bench that he will incur heavy loss? What can be done? We are bound under 141.
Even after an NPA,
Deal with. No.
even
The
after
law is very well settled. You have recourse for appeal. Seek that remedy. You can't now say that I'm unable to pay, it's huge, and that can't be entertained. How do you answer this Satyavati Tandon case? Are you aware of that order?
No. He will seek adjournment. Don't ask. He will say, I am not aware. So you have the remedy, Neeraj. Fine. Nobody prevents you from depositing. The bank doesn't have, they will be more than happy if you deposit entire amount in 1 week.
after NPA also he paid 1 lakh. NPA also recovered.
In this writ petition, mark the presence.
To entertain.
No, that's the wrong. The moment we entertain, there will be rush. Now, at least they will stop. To consistent, we entertain a case only where they will come again and we don't know where they want to pay. Yes.
My lords, I am Rao KR advocate appearing on behalf of Mrs. Madhvi Lata, my lord, item number 6, my lord. This is a writ petition filed for the selection process of the Honorable High Court's attender position in the Honorable High Court. And the petitioner has been qualified in the written examination, but for no reason, reasons unknown to the petitioner, she was not called for the verbal interview, my lord. The urgency in the urgency in the matter, my lord.
No urgency. No, we can, don't worry, we can direct a fresh interview to be conducted for you. So, but how come, where is, please show us, where is this thing, where is your result that showing that you have cleared the written examination?
My lord, I have cleared the written examination on 29/4/2023, my lord. Page number.
Page
11, my lord. Page 11.
Yes, my lord.
Page 11.
Yes.
So,
second column, fourth row.
so then why are you not calling her for interview?
The reason is that my lord, she could not produce the TC certificate of the transfer certificate, my lord. As per the information received by the High Court, the court has sent, my lord, the decision taken. The originals have to be produced, my lord, at the time of interview. She could not produce the transfer certificate.
No, to interview, when is the interview scheduled to be held?
Interview started, my lord, on 12/10. It is scheduled up to 21/10.
21.
12:10 to?
21/10.
So why she has not produced transfer certificate?
Because she has appeared privately, my lord, therefore she could.
Transfer certificate?
When SSC.
No, where is the which communication she has been asked to produce transfer certificate?
Well, there is no such communication. Or
Then
in fact, my lord,
which is the requirement?
clause also, I wanted to submit fairly, my lord. Clause also does not specifically say, my lord, that transfer certificate has to be produced. Notification, my lord, clause 12, which says only original certificates have to be produced. It does not. Page 39, my lord.
What is their letter appear in the interview?
Yes.
A humble prayer to include her in the interview list, my lord, so that she would complete it
Clause
by
A,
before the
12 clause A.
No, but this TC certificate is included.
Is not there in that clause.
Not there, 12A. Mark the presence, heard.
May it please your lordships. The tribunal below has no jurisdiction over the cooperative societies which have been registered in a state. The NCLT has no jurisdiction over the cooperative societies which have been registered in a state. That has been made clear in the recent judgment of Mr. Justice Nariman, which I have filed before your lordship. Hence, the present petition, praying your lordships to stay in the tribunal proceeding with the matter.
No, that is not appeal, but that we should appear. What prevents you from appearing before NCLT and raising objection or filing a petition? Raising an objection before NCLT that it has no jurisdiction or filing a writ petition. The question is, merely because of property situated in the state of Telangana, you don't create a cause of action.
Yes,
This court does not get a cause of action, no territorial jurisdiction.
cause of action arises in Telangana. Cause of action arises, part of the cause of action arises.
That is your submission because property is situated here.
Yes, my appearing before a tribunal which has no jurisdiction, IBC does not apply to, central laws do not apply to cooperative societies. That has been made clear by Mr. Justice Nariman.
See,
But IBC does not apply to me.
that's the, we are on the cause of action. Yes. That you have argued that since the property is situated, therefore this court has got jurisdiction.
Two 26(2) says below. 226(2) says.
Part of cause of action.
Cause of action. And if your lordships are pleased to peruse section 16(2).
See.
The lordships are pleased to peruse.
No, we are on the, we will go to the merits first, provided we are convinced about territorial jurisdiction, any case law, anything you want to cite.
Please your lordships to go into the merits.
Not fine.
I'm confined, my affidavit is confined to the question of jurisdiction.
Fine. Anything else?
My affidavit is confined to the.
You please argue your case whatever you want to. We are hearing you. Yes.
IBC does not apply to cooperative society.
Yes.
The NCLT is a creature of IBC. NCLT is a creature of IBC.
Huh?
Hence, NCLT has no jurisdiction.
This move to his, close to his mic. This thing, mic close, we are unable to hear. This. So,
my voice is not audible to your lordships. My voice is not audible to your lordships.
No. The mic we have a weak this thing since we can't hear.
NCLT is the creation of IBC.
IBC does not apply to cooperative society. That is one. Second,
which are registered in a state.
Fine, we have understood.
NCLT is the creator of IBC only. NCLT is there because of IBC. So NCLT does not have any jurisdiction. Any proceeding before the NCLT is contrary to the law of the land.
There is no order, right? I mean, you are seeking an injunction restraining NCLT even from passing an order. Who knows that if you go there and contend that you don't have jurisdiction, NCLT may reject. You are presuming that it's going to allow the application and attach your property or something. No legal injury has been caused.
The purpose of a prohibition that will not is
To prevent any legal injury to be caused.
because a judgment passed by a court lacking jurisdiction is quorum non-juris. If your lordships don't grant an injunction and the NCLT passes an order, it will cause great harm. That is why we not your lordships know writ of prohibition and writ of self-reliance. Why prohibition has been introduced is to see that a tribunal which has no jurisdiction, does not exercise jurisdiction, or a tribunal which proceeds with a matter which is contrary to the law of the land. And may I cite at this stage, not only your lordship may, I'll pass it on to your lordship.
No, Mister, we are not one thing. If do you want us to adjudicate on merits? We are not inclined to. No, we are not. We must tell you to be fair enough to you that we are not inclined to entertain this petition on the ground of territorial jurisdiction. So do you want us to adjudicate still? Then you will say that my right to file before NCLT has also been taken away.
Whatever your lordships are pleased to say, your lordships may say so.
Okay.
But my submission is.
So the three submissions, 1, 2, 3.
NCLT has no jurisdiction at all. Because the proceeding is contrary to the law of the land. The proceeding is contrary to the law of the land. I already filed the judgment of the Supreme Court of Mr. Justice Nariman, which has made it crystal clear that central laws do not apply to cooperative society.
No, he doesn't want to appear and want to this thing to be quashed here in the writ petition on the ground that it has no jurisdiction. That's it.
And your lordships know that jurisdiction cannot be conferred by conduct of parties nor by an order of the court.
No, obviously, by consent also, no jurisdiction can be conferred, correct?
Because I don't know whether I correctly understood your lordship or not. Your lordship wanted to appear me before the NCLT. I don't
know. Whatever you are arguing, you can argue before NCLT also. That's what we are saying.
Why?
No, this is, we don't have any territorial jurisdiction. Office registered of company challenge to the motive who are seeking micro. Anyway, court must have a nexus. These people are not assuming what's the leading judgment on this. Small part of cause of action. The same by itself would not be compelling to keep alive against appellant to decide the matter. This. Certain facts. See, this petition, only thing is para 6. And property 82. They ever maintained regarding jurisdiction.
The question of an alternative remedy does not arise.
No, not alternative.
No.
Acha. Yes.
NCAC is also the creation of IBC.
No, we are not saying about any alternative remedy. No order has been passed against you. Where is the question of alternative remedy? Does not arise in the facts.
Doesn't arise. No, not by submission that the NCAC has no jurisdiction.
That we have noted.
And your lordships may be pleased to restrain it from proceeding.
That's it.
Applies to your lordship.
All right. Yes. This writ petition under Article 226 of the Constitution.
Lordship is pleased to dispose it all. Your Lordship is pleased to dispose it all.
I think we dictated the order in open court, right? We dictated the order in open court in your presence, in the presence of everybody else. You want copy today? Copy today. Yes.
Obliged, sir.
Yes.
Please submit.
Ah.
My lord, the petitioner had applied for the post of office subordinate.
This is a case of overqualification, my lord. Clause 5 says only between 7th class to 10th class. Clause
But
5,
which provision says over qualification will be?
my lord, clause 5 of the notification kindly. Page
No,
number
but what is
90,
the-
page number 18.
Validity or like
Lordship, she passed only 10th class, my lord.
1 minute. Let us not be ever enthusiastic in saying that you have failed intermediate examination. The legal issue you will not argue, right? You have not brought it, you will not argue it. We are trying to, how does this clause, he may not have challenged, but what is this mystery? They don't understand what can be done. See, whether over qualification. And so assuming she has passed 12th exam, she is intermediate, how does it prevent? Which clause?
Page 18, my lord.
Can you tell your friend that he has not challenged this clause, right?
Yes, he has not.
That he is contending, but it is failed. Not
No, my lord,
overqualified.
degree also she has she appeared for degree examination also.
Your Lordship,
Degree.
she applied, but she failed intermediate.
Page 59 of.
So, Your Lordship. Basically,
Failed degree also.
SSC pass, Your Lordship.
You cannot this thing, right? Punish a person for failing in the examination, right? No, but how can you appear in the degree examination unless you have cleared the intermediate examination?
Distance education, Your Lordship.
Oh. Distance education, you need not pass the qualifying examination.
Yes, Your Lordship.
Even though I may not have 10th degree, I can straightway appear for a postgraduate examination, distance mode.
Well, but transfer certificate of intermediate says, my lord, intermediate is completed. That is at page 55.
Your Lordship, you have filed a memorandum of marks.
Second year completed.
Second year completed, yes. Ask brother. That will point to you. Tell him that he needs to challenge this clause.
Page number 61.
Hmm? Can't be ground. Can't be ground, but he will not challenge that provision.
So also, see, you have not challenged the provision qualifications. Have you challenged that?
Arey, madam, you understand? No. You also don't understand, right? You go there and tell them what do we want. We are not against them, but see, it is coming from them. What happens, Mr. You must realize they think that we are enemies, right? So we can't think in their favor. So when you tell him, they will immediately understand. Right now, what they are thinking is that court is suggesting so that our petition can be dismissed. So you go and tell them that what they are required to do. Conception is if we say something ending is like you can't, they will not see, they will understand now. Yes, understood. You have not been able to convince them, right? So we have to engage a senior counsel, right? Amicus curiae. Who is senior advocate? Present in the court.
And insofar as interviews.
Yes, Mr. Senior Counsel, please come. We need your assistance now as amicus. This petitioner, 1 minute. Petitioner has appeared in some examination where the qualification prescribed is 10th pass. and according to the respondent, they have not been called for interview because he has not only cleared intermediate but this thing even graduation level, like appeared in the second year graduation level examination. That petitioner is disputing. Apart from that fact, what we are of prima facie of the opinion that if a candidate possesses any qualification excess and above the prescribed one, he can't be disqualified. This is an unreasonable clause. So they have not challenged it. We are inclined to accept their challenge, provided they challenge it. So we are trying to convey, they are unable to understand. What he is trying to argue is that I have failed in intermediate, I have failed in 12th, higher secondary exam, in degree examination also. So, I mean, please tell them that this come to see this thing, Mr. Page 18 of the writ petition. Page 18 of the writ petition, see, this clause needs to be challenged. We are trying to tell them that, but see, Mr. Senior Counsel, see, clause 8, this thing, clause 5A. Right, 5A.
Must have passed any exam between 7th to 10th class and equivalent exam, who is having higher quality. This clause has to be challenged.
So this they need to challenge. We are inclined to permit, but they are, see, because what happens, we are telling, so they consider us our enemies, so they will not accept what he has failed in his attempt. Why you did not succeed, Mr.
I found, he's
Informed means you should have told them to amend the petition. They are not doing it.
They're saying it is challenged, but I can't see in the prayer portion.
And in that fresh reflection, he challenged this.
Can we permit
But I could convince them to withdraw the reflection with liberty to file a fresh reflection.
No, they can amend it.
They can also. You can
Amend also. We are willing to accept the point, right? That it can't be a disqualification.
You can do it at the earliest.
Your Lordships, we are undertaking to file the amended petition. In the meantime, interviews are going on, Your Lordship.
No, unless you do that.
No, we will get. But they should understand, right? They ask them to, at least advise them to file it. We will take it up tomorrow. No, this thing.
File it today itself. Go to it.
I just wanted to bring it to your Lordship's notice. Insofar as this Bhopalpally district is concerned, my lord, interviews are over on 14th, my lord. I just wanted to bring it to.
So in any case, we will have to direct, I mean, what relief can be granted, that we will see.
Also blessed.
But instead of arguing that, they are arguing failed. So we are asking, see, second year of graduation completed, how they can complete if they have failed in intermediate examinations. So he is telling us distance education mode. What? We don't know what sort of education.
But we want it.
We will list it tomorrow. You file today.
Yes, my lord.
After arguing the matter to some extent, learned counsel for the petitioner prays for short accommodation to enable him to challenge the validity of paragraph clause 5A of the notification dated. But you think about it, Mr. How can this be that?
I followed what you.
No. You could have said we can understand. The one of the objects can be if overqualified people have recruited, they will not work. Understandable. So therefore, you can differently word it by saying that having minimum qualification will be preferred. But how can you disqualify?
The
We don't know.
wording appears to be.
You think about it.
Wait, please.
Admission. What? Yes.
Before I start, I just start.
What started? This is for admission, madam. Not confident that you have a case.
We have a case now.
Then? Yes.
Well, the contempt appeal is filed against the order of the single judge, my lord. In contempt case. So this contempt appeal is filed based on the against the order of the single judge.
Hmm.
But the original Rictapalan died. LR application.
Third on IA number 2 of 2023. Reasons.
When 3 are LR petitions.
No, but who died? Both appellants or respondent. Then we will like to issue notice.
Rictapalan died. Respondent.
So why two applications? No? Give Madam IA 2 of 20.
Two may be withdrawn, but that's what I understand.
First appellant number 2, appellant number 2, and IA 3.
3 is LR.
No, 2 and 3 are both.
It says one
Same purpose.
same purpose.
No, why two applications for seeking substitution of LRs of appellant number 2? Learned senior counsel for the petitioner seeks leave of this court to withdraw. Within 1 week, 2 weeks, 2 weeks. Let amendment be carried out within 2 weeks. Please thereafter. Appeal is admitted for hearing. Right, next. None for the appellant, record peruse the appeal.
Writ appeal filed against an order of single judge, where an MARP order has been set aside by the court. But lordships, my only grounds are on two grounds. One, they have an alternative relief under section 34. And second one, my lords, that limitation has to be looked into. Even the statutory limitation has to be looked into, my lords, even though while entertaining the writ petition.
No, but this thing 34 alternative remedy whirlpool may apply.
But even otherwise also, my lords, courts have been consistently been holding, my lords, especially in MSME matters, because they have to comply with the 75% of the deposit tax as per section 19. By filing this writ petition, my lords, they are not.
No, see, Mr. How do you meet the finding no compliance with procedure under section 76? Violation of mandatory procedure 28(2) and this thing. He was not a registered supplier.
Well, I'll answer the second point first, my lords. He was not a
Whatever.
Yes.
So if he is not a registered supplier under section 2N of the Act, how can?
The question about registered supplier, my lords, that question was not raised before at the time of arguments, my lords. However, my lords, the lordship will take page number.
What is the decision of Supreme Court in Mahakali Foods?
Yes, my lords, I'll answer that query itself, my lords. If the lordship will take page number 40, I have been a registered supplier in 2013 itself, my lords. The Mahakali judgment.
We will hear it sometime after vacation. List after Dasra vacation.
My lords, lordship may give a date, my lords, that's all.
Date. Which date? 2nd November?
Yes, my lords.
2nd November.
Okay.
I am for the appellant in this matter, Lord. Writ appeal is filed against the order passed under singles, by which order to demolish the deviation of sanction plan. Thank you. Then, when the respondent hearing filed a contempt case. Meanwhile, the GHMC authority demolished the
deviations by the appellant here. But the respondent
For R1 in this.
demolish more and more. And as far as the order is concerned, Lordship, please see the page number 14. 14 is the order.
Who is appearing for respondents?
I am for the R1, I filed the wicket stay petition and the petitioner for, I am for the petitioner in the writ petition also, my lord.
Huh? What do you say with regard to IA?
Pardon?
IA, what do you say, condonation delay?
Yes, yes. If the reasons stated in the condonation of delay are produced by this honorable court, everything will be revealed, my lord. What reasons he has stated for condoning the delay? The impugned order is dated 2/8/22. When the writ appeal is filed, what the reasons he assigned?
No. So you are required to tell us, Mister, you are assisting us, right? You are not when it should be, so we will not find it out. So you, so then you tell us. The order was passed on 2/8/22. Then when the appeal was filed, and what is the reason assigned? You tell us.
Not.
Or we will ask him. Yes, is his application. So wait, Mister, how much is the delay?
Because the nearest family member was in serious condition in the hospital.
Huh?
That's why they,
Nearest member.
appellate hearing could not proceed with the case.
Who was in hospital?
Arguments are filed, Lordship.
Huh?
Page number 32.
No. He has filed the application.
These are the appellates. Page number 23.
He has filed vacation. We are distributing.
Page number 32 onwards.
Sir, you have already filed vacate stay. We can hear matter, this matter.
Today.
Can we hear beyond after vacation? What is the urgency now?
Wicket stay petition.
My humble
What is the urgency now?
If your lordships are so pleases, I may submit the few facts, my lord, leading to filing of this writ appeal, how the appellant misled this honorable court and I obtained the interim order. Initially, the writ petition is filed, my lord, by the.
No. First tell us then condonation delay.
Yes. Condone delay.
So 2022 limitation expired. Then what happened?
Yes, let him explain, my lord.
No, order.
Appellant has to explain.
But Supreme Court has been very liberal, Mister. In 181 days delay, I don't think you will be able to defend our order in Supreme Court, supposing if we feel convinced. So it's better to contest on merits.
With great respect, I certainly agree with your lordships, but not in these type of cases where
all right.
reasons assigned by the
1 minute.
are frivolous.
1 minute. So 2022 the order was passed. Then what happened?
Then he has to explain, my lord. I am.
That's all right. You have to explain.
That's my.
You argue on first condonation delay. So what happened? 2nd August. Mister. 2nd August 22 was the order was passed. You were a party in the petition. Then what did you do?
He was in delicate.
When the limitation expired.
Order passed on 2/8/2022, Lordship.
When the limitation expired.
Second September. And another aspect is that.
So what happened? Why you did not file up to 2nd?
In that writ, I was not the counsel, Lordship. Some other counsel was there in that petition. Subsequently, I have filed this writ of it. I was not the counsel.
He has to explain. You cannot get away by saying I am not the counsel. We are concerned with the delay caused in filing the appeal.
As far as the nearest niece is suffering a lot, serious condition. That's the entire family was suffering.
and taking care of that. That's why he could not proceed properly.
What suffering means what? Like,
Some serious condition about
you read para 4. Mr. Atlee, the court should adopt a liberal approach. That doesn't mean that you will not offer any explanation.
Yes.
Please read para 4.
Para 4 of Lordship.
Para 4 of your application.
You will ask us only, right? But don't read anything. You argue whatever you want. This thing it is not our job to tell. So niece was suffering from this the only sentence, right? All right. Or wrong IA number.
That's why he could not.
Anything else?
And as far as the order concerned,
No, condonation of delay first. The niece was suffering. Which niece? Nothing, no name.
name is there.
Name is there. What disease? Nothing, no medical certificate, nothing.
She was carrying pregnancy. And
It
she was
is
suffering
not-
lot of
it is oral submissions, right? Not there in para 4.
documents are speaking.
From which period till which period he was ill, when she was hospitalized. Absolutely vague and baseless.
Medical record is
Fine.
concerned, that is subsequent. But as far as suffering is concerned, prior to that.
Sir, you are supposed to explain the delay. What caused the delay on day-to-day basis on a strict interpretation?
Not, even it may not be strict, but he has to explain the delay. When she fell ill, when she recovered, when she discharged from hospital, when he applied, nothing. We'll dismiss the petition. I'm the person, but what to do? He's not even asking for additional affidavit. These people, what to do? That's it. Anything else?
Not in my humble submission. As far as the
What we will pass an order on condonation, then only it comes.
along with the condonation, he filed certain documents. I want to refer that document. The GHMC authorities have filed a counter. And in
No. There's no question of filing counter. We are on the question of condonation delay. So niece fell down. Niece was seriously ill. That's it.
That's why entire family was suffering. That's why he could not file the.
Why the niece would suffer, and if somebody is ill, he would suffer, right? You are also suffering. So from when nothing. There's no period.
The confusion. That's why.
Mister, there has to be a period of suffering everywhere, right? There is a period of suffering. Somebody,
Lordship, please.
You know what?
In the interest of justice and the protection of the rights, Lordship, please consider. As far as the factual aspects are concerned.
Mister, you are not even offering to file an additional affidavit. We have no other option but to dismiss the application for condonation of delay because you are not even making a prayer filing an additional affidavit. What can be done? See, this is how you test our patience. The appellant should thank themselves for engaging a counsel like you. Any other person after going through paragraph 4 would have said that, sir, please give me time. I will file a better affidavit explaining the delay. You are not even doing it. You are provoking us to pass an order. You are asking us, what should I read? As if it is our case, right?
I'm sorry, Lord.
Don't, Mr. All the time, it is never this thing. You are officers of the court. You have the equal responsibility to assist us. All the time, you cannot leave everything. You are see the height of carelessness. You are asking, what should I read? We are asking you to address arguments on condonation of delay as if we will ask you to read para 4 of memo of appeal. You are asking, what should I read? You don't have an idea what to argue. We can't.
Sorry,
my brother said that all the time we cannot give advice to you. It is none of our job. Go to Supreme Court. If it will be set aside, we will hear it. Go there.
Permit to
Yes.
file additional.
Do you need an invitation from the court?
I'm sorry, Lord.
Better behave yourself, Mr. Amend your ways. This is not the way to address a high court. Niece was suffering, I was suffering, whole family was suffering. What sort of?
With the due respect.
I am this would have been the first exception in my career. 14 years, I have never this thing because the your opponent is a very technical person. Therefore, otherwise, as a counsel, I have never opposed any application for condonation delay, and I have never dismissed. But this would have been the first occasion because of your attitude, because you are not to see what is there in para 4. Even if we want to allow, we cannot allow your condonation delay. There is absolutely no explanation. When the limitation expired, when she fell ill, what happened, when she recovered, when did you apply for copy, when did you get it? Nothing. That liberal attitude doesn't mean that even in the absence of an explanation, also the court should condone the delay. Nothing. So we will dismiss your appeal. Go to Supreme Court. Condonation of delay.
It will be considered for filing an additional affidavit. All the explanations.
What is there? You have not explained it. Now finding out, creating, why to get into trouble creating forged documents with regard to illness of your niece, bribing somebody to prepare medical record, producing it. Oh, what to do?
Humble submission.
What do you say, bro? Should we grant? No, should we grant? After arguing the matter to some extent, learn it. No, when a query was That's why he is filed.
No, my lord.
Obvious.
No.
What is your locus? I mean, like.
My lords, I am the first citizen of the municipality. I am the municipal chairman as per the Telangana Municipalities Act 2009.
Are you not responsible? Your body has granted this thing. Municipal corporation has granted approval to them.
Absolutely for the building permission, my role is, my lords, not to grant the pollution control consent, my lord.
Yes. That's the point.
Yes, my lord.
What have you taken action on? No, Mr. They are saying that without clearing environmental clearance from Pollution Control Board, these industries are being run.
Yes, my lord. They obtained
With representation, huh?
They obtained the consent.
Where is that? You produce?
Yes, my lord. I filed a report, my lord.
Fine.
I filed a report, my lord.
When? Have you supplied a copy to the petitioner?
Yes, my lord. Last week, the month of July itself is applied.
Where is he?
One copy.
Huh?
I do not have, my lord. I'll take from him, my lords.
See, they all 3 to 12 have met officers of Pollution Control Board and got the consent without meeting you. Huh? Which is it?
My lord, as per the RTA Act.
No, see,
The pollution control board.
you see the report.
Page 2, not in this record, officials inspected the responding 3 to 12 members, industries and
So
municipalities.
see, 1 to 4 industries have already been closed. Therefore, they are not meeting you. Correct?
No, my lord.
1 to 4 is already closed, so no interest left.
And in the RTA Act, they replied saying that they have not taken consent. They're still running. But maybe the name, they have changed the name, but still running.
Mister, you need to. This is the report. Somebody, what is this? It has to be accompanied by an affidavit, Mister. Nobody owns this responsibility.
Environmental engineering.
File an affidavit. No, Mister. This like giving a report. Tomorrow he will say that I have not signed this. So how will we hold responsible?
Okay,
He will sign, sir. I don't know. I have not signed this report.
Well,
What is this? Learned counsel, the grievance, the petitioner who is and says so on affidavit that these simple, right? These industries have been closed. These industries environmental clearance certificate has been granted on these dates. Only 2 paragraphs sufficient.
And save the narrated in the report, my lord. We'll
Yes.
get the affidavit count.
Yes.
The offset match is there is the whole
Huh?
So yesterday, unpreparedness regard the dates my loss.
Ah.
Period of week and a list of dates.
So what? Converting the. Yes. So what? When was the examination held? Again, same questions which we remember, which we asked you yesterday. When was the examination held?
It was held on 5th of March 2023, my
5th of March 23. You are a candidate belonging to
PWD category.
All right. So when was the result declared?
Result.
14-3, my lord.
14/3. 23. Oh, within. So then when was the list published of candidates?
Notification merit list in the first merit list, I was not selected, my lords, because
When was it published?
in the list which was published on
February 9/7/2023, my lord. Notification was issued. Calling, my lord, the eligible
we had
candidate.
Notification, 1 minute, notification.
9/7/23, my lord. Calling up, my lord, eligible candidates to make online applications, my lord, from
To
from 10/7/23 to 17/7/23, lord. That the provisional merit list was published on 31/7/23, my lord. But 1/8/2023, my lord. That the asking, my lord, PWD candidates to appear before the medical board on 3/8/23, lord. But on 8/8/23, my lord, the merit list of PW candidates were published. Only 6 candidates were found eligible, my lord, out of 36 seats. Notification for first phase of counseling.
1 minute.
Notification for first phase of counseling 12/8/23, my lord. Comments from 13/8 to 15/8. Lord, notification is, my lord, the 12/8, my lord.
13?
Lord, web options
13/8 to 15/8. 13/8 to 15/8.
Yes, Lord. Web options. Lord, this allotment for seats with competent authority quota, my lord. Then the.
No, when was the notification for first phase of counseling?
Lord, 12/8/23. 12/8/23. Web options.
And then 12/8 to 15/8 web options.
Yes, Lord.
Then.
Lord, second phase of counseling on 8/9.
Then when the seats were allotted?
Lord, the first phase, Lord, all the seats were allotted, Lord.
When?
Lord, the allotment is on, Lord, may kindly say 17/8, Lord.
17/8.
Yes. Lord, the second phase of counseling notification was issued on 8/9/23, my lord.
Second. 8/8.
8/9/23. Lord, web options from 9/9/23 to 11/9/23.
9/9 to 11/9.
Yes, my lord. After second phase of counseling, my lord, Lord, the NMC reduced, my lord, the percentile, my lord, eligibility criteria to 0, my lord. Lord, whoever, my lord, the apply, my lord, NEET appearance is sufficient. Then the petitioner become eligible. The notification was issued for registration, my lord, that is, my lord, 21/9/23.
So petitioner applied, didn't apply.
Subsequently, my lord, after he was
applied,
qualified, he applied.
So then what is the grievance? If like seats are vacant, 0% has to be given, then he has to be given.
Let's make kindly see. But after first phase of counseling,
0% means what 0%? 0% marks or 0% disability?
But only appearance NEET is sufficient. But you have become eligible.
No. Like 0% in examination or this thing?
Zero examination.
Examination. So he is entitled for admission.
Yes, he is entitled.
Then why?
I just submit. After first phase of counseling, the university doesn't know that they are going to reduce it. In the second phase of counseling, leftover seats were converted. After second phase, leftover seats were converted into general category.
Leftover means 30 seats.
Total 36 seats.
So 6 were admitted.
6 were admitted, 30 seats were converted into respective categories.
30 seats.
30 seats, because it's a horizontal reservation. Converted.
So now what happens to him now? He is eligible, you tell us.
The university doesn't know that
correct. So had they been filled up?
Then last week kindly see, the notification was, mop-up round of notification was issued, seats were filled up.
When mop-up round?
Mop-up round is,
When this zero criteria was 0.
23. 3/10/23.
Criteria was reduced to 0 when?
Lord, may kindly see, Lord.
Huh?
21-9, Lord, 21-9.
21/9.
Yes.
So then, and on same way, that very day you issued a notification
For registration. For registration.
for registration.
Yes.
Then, so what happened?
Lord, mop-up round was conducted, Lord.
One, when?
Mop-up round was conducted, Lord, may kindly see, Lord, on 3/10/23.
310. Then,
Lord, subsequently, Lord,
whether he participated? No.
because no seats were available. If no seats were available, Lord, he was not allotted any seat. No seats under PWD was not available.
Now what?
Then the stray vacancy round was also conducted. The petitioner came after the
Stray vacancy round conducted when?
stray vacancy, Lord. 14-10, Lord.
14?
14-10/23.
Ah.
And college-wise allotments were made on 17-10. After that, my friend filed a writ petition.
Oh.
Bloody, had he come bloody earlier, he could have adjusted
Delay
plus
and latches.
I filed on 13th, my lords.
One. Petition filed on 13/10/20. Yes. And what is the prayer in the petition?
I have only one submission, my lords.
1 minute. Of course, you will be heard. This only exercise was to understand what is your case. Because since yesterday you are unable to explain it to us. I submitted that I have a fair chance. Then what is the prayer? Where is the prayer?
Here. Page 18.
Page
18.
Writ of mandamus. So those obviously now at this point of time, what can be done? Yes. Yes, please.
My lord. The respondent number 2 had to follow medical counseling committee, lead PG's counseling scheme, my lord. They are bound by it. I have filed the document, my lord. Document may kindly see page number 24. I'll trouble
No,
you.
no, no, Mr. One thing. 21/9/2023, you are made eligible, right?
Yes, my lord.
So what were you doing from 21/9 till 13/10?
Seat matrix was only issued on 310, my lords. Only then I got to know that the PW seats have been converted. Only on 310.
So who has been given admission? Who has been given admission against those seats?
I have been informed that the seats have been converted into general category, my lords. The only submission, my lords, the university was not having powers to convert, my lord. They can convert only in third round, only when the eligible candidates are exhausted.
No, who are the parties to the petition?
But it's the state of Telangana and the university, my lord.
You are asking us at this point of time to cancel the admission of a person under a PWD quota converted seat who is not before us. How can we do it?
So the entire process which has been carried out is irregular, my lord, violating the counseling scheme. At least they should save one seat for the candidate, my lord.
Why one? They should reserve 10 seats for you. Why only one?
Only the petitioner is so vulnerable.
You want admission in a particular college, they should give you in Hyderabad. Why should you be asked to? Mr. Rao.
May kindly consider the second time approaching the honorable, but even in 2016 she was eligible, but she was qualified because due to her disability she was not allowed to take part in the process. Again, she is approaching the honorable court. Some relief will be granted, my lord. The entire process is per se illegal, my lord. Because they have violated the counseling scheme. They were not having the powers to convert. The scheme is specific. They can convert only in third round. So lordship permit, I'll just read it, my lord.
Why not? Where is, have you filed it?
Yes, my lord. Page
Which
number
page?
24, my lord.
24.
24.
it reads, my lord, the conversion of seats will be carried out during the online third round. The said conversion will be done only when the eligible candidates belonging to the said category have been exhausted. The algorithm which needs to be followed.
That is All India quota. That's All India quota. Under rules, rules
This
issued.
is all India quota.
That's All India quota. The rules issued by the state government, admission rules, confers only after second round they have to be converted.
Which rule?
The rules have not. GOM is number 155 lordships.
Where is it?
For last several years, this is the procedure.
No,
is
but
being
you
followed.
tell us, that is the question. What? You have what? Oh, you give it to Mr. She has GOMS. Yes. What can be done at this point? So Mr. This thing, mop-up round held, stray vacancy round held, everything is over now.
So, no seats are available. That is, rules are not there.
Not there.
That's me put it tomorrow, my lord, I will find. That's me kindly pardon me, my lord.
Learned Mr. A. Prabhakar Rao, learned standing counsel for respond number 2 university, prays for a short accommodation to enable him to seek his step.
It also can be disposed of.
Huh?
Both matters can be disposed of. The writ can also be disposed of.
What? Writ?
Because this matter arises out of the proceedings before DRT.
Huh?
The petitioners before Lordship filed a claim petition in RC 483 of 17.
So what was it? It's Satyavati Tandon or what?
No, I think my matter is next matter, 21, 22. Yes, there are two matters, my lord. These are
No, one case is, Mr. 1 minute. Item 20 is an application. It was dismissed for want of prosecution.
Yes, my lord. I have filed an application for restoration. This matter, the next matter will go together. But the writ itself can be disposed of, relegating us, directing the DRT to dispose of the claim petition filed by us. My lord, in recovery proceedings RC 483 of 17, my lord, this property was put to auction. It's proposed to be put
No, so what? No, you have approached the RT, right?
Yes.
Then what do you want?
My lord, let the DRT decide my claim petition, my lord. That is numbered as 151 of 2017.
151 of
2017 in WP 21294.
Oh, WP. How can there be WP before DRT? Claim petition, right?
No, in writ petition number 21294 of 21, the claim petition is 151 of 17 in RC 483 of 17. Because there are two.
So what do you want? So you want a direction?
Direction, my lord, I have deposited 1/4 of the amount, 25 lakhs in terms of the interim direction of this court. Let the
let me.
May I give few
Declaring notice dated. Please to issue writ mandamus declaring notice dated 31/8/21. What is notice?
That was a proposed auction, Lord. Now that is now that has become infructuous. So far that aspect is concerned.
So it has become infructuous then. Well, there is nothing.
No, Lord, Lordship may direct the DRT to dispose of my claim petitions which are pending.
Correct.
There is no such prayer even made in the writ petition, my lord. Your lordship.
That's what he's saying. Not even the prayer made in the writ petition. What is?
So at that stage, my lord, because I want an early disposal so that again I don't come back. Again, there is an auction. I only want the matter to be decided. Now, this so far as this is concerned, the date has passed and it has become infructuous.
So then we will dismiss your
The
petition.
condition here was, no, the
Hold on,
condition
IE number.
was, since the
1 minute.
claim application is pending before the DRT, they cannot auction the property. Now, anyway, claim petitions there have been pending for the last 4 years.
We will hear you on merits, Watson. When you come here, we will hear you on merits. Because Council for Bank is opposing, we are allowing your application.
Much obliged. Much obliged.
So what is the objection? If something is pending and we direct to decide to DRT, what is there? It will never be decided, right? So you don't want to be decided. What is the objection?
My only difficulty is RN number 30. Your lordship.
All right, so then you, Mr. Prabhakar, you will have to argue the case. He is opposing. Council for Bank, naturally he will oppose
In fact,
everything.
my clients are prepared to pay it in installments if they don't want it, because they have
They don't want, they are interested in your property. They have the banks have become like agents, right?
Take 2 or 3 installments.
They have become the real estate agents. They sell the property of people and their officers itself in the garb of their relatives purchase the property. And that's why they.
Because he's an agriculturalist, he was
Hold on, IE.
clear the law.
This is IE. We are allowing this IE. What else?
Much obliged. I am deeply obliged.
Hold on, IE 2 of 2021. You are opposing even this IE.
Opposing the resolution application first, the lordship can be shielded.
Oh, Mr. Prabhakar. Oh, he wants to oppose your IA for recall also.
Let him file a
Learned counsel for the. Yes. How much time do you want to file this IA? This reply to this?
1 week time. Your lordship, I counted may not be expired. Your lordship can hear me. RN number 13 of their writ affidavit. Your lordship can. He's a third party who is not a borrower or guarantor. He says he has purchased.
No, we are, Mr. He is saying something else. You are saying something else. We are dealing with an application for recall. You want to file objection to this IA, right? I mean, this is not done, Mr. Never do it. We have great expectations from you. Like, don't disappoint us by opposing the prayer for recall. What do you think? If you file an affidavit running into 50 pages, we will reject the application for recall. And we will never allow, in case your petition is dismissed, then we will remember this, that
I'm not
fair. Not fair. You file, Mr. This. We are really we are disappointed, Mr. We always thought high of you. This is the conduct which is not becoming of a fair counsel. We are bound to grant time. Learned counsel for respondent bill.
That may not be
for adjournment.
For a moment. I'm only intending to.
Mr. What is there to oppose the recall? We have told senior counsel that we are allowing his application for recall. You are approving. You are arguing on merits. He is arguing on something else which is not there in the prayer. We cannot tell him. That's why we have said that we are only allowing the application for recall, because he is insisting on something else. According to you, we have understood. But the petition has become infructuous.
You'll ask me.
You prayed for 1 week's time, we will grant you. For the respondent, it's for under an obligation. You are perfectly well within your right to file counter to IA for recall. We can't oppose this prayer. We have to grant you time because the learned counsel for
We'll conclude the matter tomorrow.
I have no objection. I am ready.
We always thought of like that you will never oppose. So that's why we told senior counsel without hearing you that if any other counsel would have been there.
Counsel would have, my only submission was that in the data affidavit they have sought 2 weeks time for paying the entire amount. It is 2 years have lapsed, they have not paid any amount to the.
We are not concerned with this thing. Mr. We are not bank. We have not granted him loan. We have nothing to do with whether he pays his. You have passed under 13 for do it. Who prevents you? Is there a stay? I mean, I really strange, but you are arguing on an application for recall. I mean, I can understand that you say that, sir, if you are allowing the court is allowing the application for recall, I pray that it should be heard at the earliest. Understandable.
That is what my prayer.
Then oppose no, Mr. Oppose that it can't, we should not be restored because it has become infructuous and all that. We will hear you. We are bound to hear you. File application.
I'll file my counter.
Counter to IA. Learn it.
The next matter also will go along with this.
Yeah. This is also dismissed.
No.
Yes, yes. Both are connected now, same parties.
Corrected.
No, that is.
No, but Mr. All right, when you appear, we will ask some questions to you. How you can argue in an infructuous matter that something should be done which is not even asked for? That is another aspect we will have to see.
No, otherwise, if my
you better come. First of all, we will need to decide this recall because this will be subject to our challenge before Supreme Court. So come ready on recall, right? Yes.
But I may have
Because yes, for 2 weeks time to file counter to your IA.
Very well.
Come ready. Don't take it lightly. Yes.
Even after
Bank is a very bad litigant. They will not leave you. If the forum would have been available, they would have even gone to International Court of Justice. You should thank yourself that Supreme Court is final forum for them. Bank is a very bad litigant. Yes. This has nothing to do with the case. This is this thing, right? No, bad litigant means they will give it a try, everything. Even if we order a regularization of a class 4 employee, they will take it the matter to Supreme Court. We know this from our experience. That's why it's not a bad litigant. They have a right to approach. This is a fundamental right to file reply to restoration. We can't take it away. Yes.
In the present matter, pleasure to me not additionally Sri Narasimha Sharma is appearing. This matter additionally is additionally is appearing.
But I have the pleasure of being opposed by the additional solicitor who's been just appointed.
Yes.
I'm waiting.
What is?
So it's my pleasure to be the first one against him.
Yes.
Yes.
What is it?
But I'm sorry we are troubling your lordships in this matter again. My lords were pleased to admit these two writ petitions.
Yes.
But they question validity of certain provisions in the GST Act. But also pleased to admit the writ petition. When it came to interim order, my lords, I had shown an order of the Honorable Supreme Court where they said that no coercive measures should be taken provided some 10%.
They made a statement.
What had happened is, unfortunately, my lords, my learned friend relied upon an order passed by another learned bench of this Honorable Court.
Where is that order?
Yes, that does not really protect. That's a problem, my lords. And in fact, even after that order, they had arrested one gentleman. So this is my problem. Your lordship will kindly find that order, my lords, in the first matter in page number 135.
Supreme Court.
135.
Supreme Court, right?
This court.
135.
This, our court. Your lordship is wanting to see the Honorable Supreme Court order, my lords?
That's what.
Yes, I had passed on copies on the earlier occasion. May I pass out additional copy?
Yes. Mr. What do you say?
But
in a similar matter, Supreme Court has granted. What is the order?
In Shota, identical matter, my lords, is of the AP High Court. I had passed on that copy also to your lordships. I may again pass on the copies of the AP High Court. Copies.
What is these are some conditions like
yes, I mean what the Honorable Supreme Court noticed is that even if an appeal,
what you are being prosecuted, what has happened?
What has happened is two persons have already been arrested by
the respondents in this particular case. And my lord, one person has moved Odisha High Court for bail and they have now asked for cancellation of the bail so that my lord, they can arrest him. He has appeared before the authorities on 4 different occasions. And my lord, so far as the compliance, namely depositing 10% is concerned, after adjusting whatever we have deposited, we are willing to comply with that order, no issues. And my lord, we are sincere taxpayers. We have paid 130 crores in the last 5 years. And my lord, the disputed amount is only about 10 crores. And which is also based on the provision of law.
What is the interim relief you are praying for now?
No coercive measures insofar as the petitioners are concerned, subject to my lord, your lordship.
No coercive measure for?
My lord, they have arrested 2 people already. And my lord, the third person who has taken a bail from Odisha High Court, they have moved to Odisha High Court day before yesterday for vacation of that order. And my lord, for his arresting.
Why? Why you are being arrested? Why? You must have committed some offense like...
The issue is basically this.
No, you have, as we understand,
yes,
you have challenged the validity of section 62C and 41(2) of Central Goods and Services Tax Act.
Yes.
That's it. So what it has to do with your arrest?
Yes, I'll tell you, Lordship. But basically, this provision which has been challenged before your Lordships and 6 other high courts, deals with the issue of the input tax credit. If the input tax credit has not been, whether the previous vendor has not paid that tax, then the Lords, it can be collected from me. But my submission is that it does not afford me any ground to proceed against that person. For default committed by a third party, I cannot be mulcted with the tax. This is the submission insofar as the bail writ petition is concerned. And these provisions have been challenged in 6 high courts, which your Lordships noticed, and on that basis, your Lordships are also pleased to admit the writ petition. Now, when the statute itself provides that that tax can be collected by me, but no purpose is served by merely arresting me. 2 persons have been arrested from this company.
Under which provision? Arrest.
Under 16.
16. Okay.
16. No assessment has been made, no show cause notice has been issued at this stage. They have the power to arrest.
Where? 16(1)?
69. 69(1). May I read it to your Lordships?
This is, yes, 132. Offense under subsection clause D and 132.
But 69(1) may be relevant first. I'll just read that to your Lordships. Where the Commission has reason to believe that a person has committed any offence specified in clause A, B, C or clause D of 132(1), which is punishable under clause 1, 2 of subsection 1 or subsection 2, he may order, authorize any officer or central tax to arrest such person. Now your Lordship may kindly come to section 132. But the clauses which are referred to are A, B, C, D. A is supplies any goods or services above without issue of any invoice or violation of provisions of the Act. B, issues any invoice or bill without supply of goods or services or both in violation of the provisions of the Act. Then C is probably relevant. Avails input tax credit using the invoice or bill referred to in clause B, or fraudulently avails input tax credit without any invoice or bill. Now, in my case, their allegation is that avails.
What is the amount due from you?
Amount due was as per the bail order. In one case, it is in the first case. In the first case, it is 12 crores. In the second case, it is 8 crores. And not that.
Yes.
Then what the Honorable Supreme Court said is, even if you file an appeal, you have to deposit only 10%, pay 10%, and then there will be no coercive measure. And that is in fact what the Honorable API High Court also has said.
Where is that one?
I passed on copies just now to your Lordship. May I just show the...
This is Supreme Court, right?
Yeah. Supreme Court, my lords, just read.
Yes.
You have a copy. And AP High Court, my lords, are identical facts. That is, with respect to the very challenge to the very same provisions, the Honorable AP High Court has granted the law. There are some amounts which have been paid.
Some prosecution has been launched against
No,
you.
my lords, we have not even been issued with a show cause notice at this stage. This is.
So what happened to the two people who have been arrested? They have been released on bail.
They were released on bail. There is a bail order, and perhaps the Honorable Court has also recorded. Our own Honorable Court has recorded that they have fully cooperated with the investigation.
All right. Yes, what do you say, Mr. ASGI? Yes.
But one submission that your notice has seen, the main prayer in the writ petition is challenge to section 16.
Yes.
Where the supplier, unless he complies with the requirement of
That
tax
will be
payment,
examined, right?
ITC cannot be claimed these people. That has been under challenge. Similar writ petitions are pending before this honorable court. Similarly, where section 16(2), same provision is under challenge.
And we think we have interim orders have been passed.
No interim orders in those three writ petitions, even one before your
No,
lordship. I just pass on those copies to you.
What do you say with regard to this?
And one more submission, Then, kindly your notice, earlier, last time, the standing council submitted, there is an order by the other division bench of this honorable court, which your notice are kind enough to say at page 130.
Which is that order? That's why we did not grant stay to them.
Your notice may kindly take that, your page 125, that order.
120.
130. Sorry, 120.
120?
It starts at 125 minutes. At WP number 20815 of 2023. Your notice got that. It starts at page 125. And kindly see minute come over to para 8 minute at page 131. This is the same petition. Your notice got that minute, para 8.
Yes.
Having heard the contentions for put forth by either side, reduced on the record, and also taking a note of submissions made by the response for the department, that 4 persons were summoned earlier have already been arrested. In the light of documents and material collected in the course of seizure for the petitioner's establishment, this court of the opinion that of justice.
So this, Mr.
Yes.
We will ask them to appear before this thing. Don't arrest them.
Yes.
They will render full cooperation. In addition, 10%.
Yes. Only one submission, just I want to bring it to your kind notice. This order is obtained on 2nd August 2023, page 125.
Yes.
To appear on 4th August 2023 before the authorities. Kindly see the director Mirad, he files at page 135 before the Odisha High Court. Kindly just see that for a minute, Mirad.
No, he undertakes to appear.
7, 8, 8, 8, 10, 8.
Sir, we are recording their undertaking, right? I mean,
I have appeared 4 times and I'll continue to appear, abide by your lordship's guidance.
Ultimately, our proceedings are provisional attachment under section 83 is already issued. That is the consequence of
they are being, see, Mr. They are being given protection only from arrest, right?
Arrest and they shall
cooperate. They will appear before the enforcement directorate.
Not enforcement directorate, GST authority.
GST authority. You must have felt scared. You must have felt scared, right? GST authorities, right?
Grateful you not direct them to appear before the authorities.
Yes. When do you want him to appear? Tell us.
Well, then issues the summons and I'll come
and then when the summons are issued by the
authorities. Hold on, IA number. Which is your IA, Mr.?
Well, sir, before that, just
IA 4 of 23.
One small thing. There are 2 IAs which your lordship may kindly permit me to withdraw first.
Which IA?
Yes,
this is item
21. IA number 4 maybe this
21. 21. Learned senior mark the presence. Learned senior counsel for the petitioner seeks leave of this court to withdraw. All right. That is will be order in IA, different IA. Yes.
But I'll ask my colleague to tell her the correct IA first if there is any confusion.
Yes. You see, madam.
Obliged. Obliged.
Now which 23 to 30 batch? Finally. Yes, yes.
It's appearing in item 23, 32 and 33 months.
23?
23, 32 and 33 months.
32 and 33.
Yes, that's matter is pending before Supreme Court. A 3-judge bench was constituted with respect to the
What is the issue?
But it's with respect to Inam's Act, a definition of Inam and a successor in interest. Whether the word successor in interest should be given a narrow interpretation or the larger interpretation was the question. That was referred to the 3-judge bench of this court. Against the orders of the 3-judge bench, which has said a narrow interpretation has to be given, parties have approached the Supreme Court. So Supreme Court has given status quo with respect to the subject properties. The matter is coming up before Supreme Court on 29th of November.
Pending matters. State is in appeal.
Which is this thing?
May I pass on the order?
Order. Learned counsel for the parties 23 to 33.
Given the effect of the judgment, not back.
Only with respect to matters possession. Status quo is with respect to
Status in respect of status quo in respect of the properties.
not with respect to legal position.
I agree, Manoj, it's not with respect to property. However, Manoj, the whole subject matter of the writ petition.
You are opposing the prayer. You want it to be heard.
It has to be heard, my lord.
But because the subject
was not said, my lord, the
Judgment.
Because the whole issue revolves around the one interpretation which the Supreme Court is going to say.
What do you say, Mr.? Do we need to decide it by passing an order whether it should be heard or not heard, or can it be on the consent?
That will not get in the way.
So then you will have to point out. We haven't read it obviously, final hearing. So you tell us who has done what, how this writ petition has been filed, what is it?
Well, it's going into the merits of the matter, senior counsel.
Not merits. Just to tell that it should be deferred.
Yes.
Yeah. They are opposing the prayer, no? The state is also opposing the prayer. They are saying that tendency of the matter before Supreme Court has nothing to do, right?
Yes, sir. I have two appeals, matters, item 24 and 25.
No. So this thing is that the SLP has nothing to do with this case.
Because the full bench judgment is not being stayed, matters, only status quo as of today.
No, but against full bench if...
I leave judge.
No, so what is in this writ petition? See, Mr. Like division bench will be bound, we don't know. Okay. As we are dependent on you for assistance, so we are in a miserable position. In motion hearing, we are not dependent on you because we prepare. So you please tell us what is the writ petition, what is the impact of a full bench judgment, what should be done?
As regards
you are relying on full bench.
No, my lord, full bench judgment is against me, my lord. Then we approach the Supreme Court.
So then go. We will follow full bench. You file another SLP.
It's already because my lord,
no, what? See, Mr. Why?
Supreme Court says.
Mr. C, please appreciate whatever Supreme Court. We are division bench. What is the legal position? View taken by full bench binds us.
Yes.
Correct. Then.
Only point I'm trying to make, my lord, if Supreme Court says either way, my lord.
No, you also go. He says if it says either way, you will also succeed.
Only my application.
No, but please appreciate. There is no stay in this proceeding. Right? There is no order granting that the High Court should not hear WP number 913.
No such kind of an order. It's only a status quo with respect to some properties, but that's the only order.
And that property in respect of which status quo is passed is not subject matter of WP 913.
No, they are the subject property of all the three writ petitions. We have only approached the Supreme Court. The status quo is with respect to the three properties, item 23, 32 and 33.
No, so what happens if we follow full bench? Status quo is disturbed.
But only point I'm trying to say, my lord.
No. We want to understand, Mr.
Yes, it's
the impact. He is opposing the prayer, so we are asking you.
But my case is simple like this, my lords. I'm a subsequent, as per the Inam's Act, my lords. The Inam authority, the property vested with the government. Subsequently, my lords, in 1973, the government was supposed to issue a certificate to the parties. That is the original inamdar. The original inamdar, if he doesn't take the certificate and if he alienates the property, whether the subsequent purchaser can he obtain the certificate was the question, my lords. That's where the word successor and interest came into the picture. In all the three writ petitions, my lords, I am the
We'll continue after the break.
Yes.
Lordship, may I permit
You tell us, Mr. Government advocate, you have to assist us, right?
Very well.
What, I mean,
Well, let's see.
like, you are leaving it to, you will have to leave everything to us only because, so there's no need you go out. We will leave it to us, everything. Everybody should go out, leave everything to us. We will go through the file, read it. Whatever is we can perceive, we will decide.
To some extent, Malas, the judgment Malas of the Honorable Supreme Court will have bearing Malas to that extent. But as of now, Malas, the
previous
judgment is
occasion
not stayed.
Previous 2 times was on the
No, no, but he says an order has to be passed. He can challenge that order in Supreme Court. That supposing if we defer hearing, he will challenge SLP. So we have to decide. We are trying to understand, Mr. No.
Supreme Court will be Supreme Court. They dispose this matter.
That issue we will.
But if that is
not, he's not ready. He can since the time for.
That's what he is now. Now you have come to the point. He in fact is the first category. I am not ready. So,
but in fact, I have to prepare for the matter. It's a batch of.
You are ready?
No, I have to prepare for the lengthy arguments.
No, what lengthy, Mr. 2004 matter, nothing, no lengthy.
Well, it's the whole point revolves around the one issue.
How many years? 2004 and now next year will be 24, 21 years. You want that it should attain the age of majority, then only I will argue, right? 21 years, not before 21, but we are not inclined.
Or else, Mr. Lordship, defer the hearing.
No, nothing. Why defer? We will come back. You find out what is it. We will at least decide. You are saying though that it should be deferred. We will decide this whether it should be. And if we decide.
Senior counsels are appearing in the matter,
But this is 2002 and 4 matter, Mr.
Yes, Lord. The whole issue is, my lords.
No, whole issue is, see, Mr. Whole issue is, we tell you, we don't own any of these lands and we don't know what is the subject matter. But the whole issue is, we have identified 27 cases from 2007 till 2000 till 2007. And these are those cases. We are taking it in a mission mode to decide these cases so that we can get rid of pendency and proceed. The difficulty is that you repeatedly seek adjournment, then this is what it happens.
My trouble also is that, my lords, if I argue the matter, my lords, obviously the three-judge judgment is against me now.
Then
saying
what
that
can be done?
Narrow interpretation has to be given. That is the order of the three-judge bench. That is being challenged before Supreme Court, and we are forcing.
So we will follow full bench. You come ready. We'll see what can be done.
But if not, Mr. Lordship, I have it on the first day after vacation. The senior counsel will be appearing.
Yeah, but senior.
But that's the only request I can make, minutes now. Only to defer it for 2 days.
No. The problem is, Mr., that if we adjourn 2002 cases, say on the ground that senior counsel, that means we are creating a category where senior counsels can get exemption. Then he is a junior counsel. We cannot force him to argue. He will also ask for adjournment. We will have to adjourn his case also.
Well, then Lordship may consider my request, and then please.
What? Let it be in the password round. We'll see. Let it be in password. You think about it. What is to be done? In such a case, you should be fair enough, Mr. I mean, you should be enough to say, at least make a statement that full bench is against me and that full bench binds. You will have to go to Supreme Court. That is.
We've already been for Supreme Court.
No. So the object is not of seeking this thing. Should be kept pending. We don't know where to. You go. The full bench, the effect of full bench decision binds us. What is the effect? It binds us.
But challenging the full bench judgment, I am before the Supreme Court, Manoj, already. The writ petitions, the SLP is filed by me, is by me only, Manoj.
Full bench did not decide the matters. Only reference was made to the full bench.
Huh?
Full bench answered the reference. That
So
is
that-
the matters to the division bench.
Yes, yes.
So that full bench judgment, Milord, is before the Supreme Court and that is the matter.
No, no, so that's what he's saying, that the full bench has nothing to do with this case.
No. The Supreme Court, he's in the status quarter of the Supreme Court as well. That's what he.
No, he has said that you are saying that matter is pending, therefore we should defer the hearing. He is saying that there is no such thing, like it can proceed.
It was not so.
We will see after the break.
What my friend
Please tell.
wanted to say, Milord, that you want to express that since last occasion, the matter was adjourned to a later date because the pendants of Supreme Court. Therefore, Milord probably was not prepared for the case.
Which order?
It came earlier, Milord. Matters came earlier before the other Chief Justice.
Which is the order?
The represented and the matters are adjourned because of that.
No, no, not the Supreme Court, madam. Order passed by this court adjourning that. Is there an order resolving the issue? Which order?
Previous occasion, Milord, matter was listed before the division bench of the first court then.
Well, you please find out. We will take it up after the break. Please see, you can go through this order sheet. Please point out. If there is an order, then awaiting decision of Supreme Court, then it has to be deferred unless you file an application for modification. If the order is not there, we'll go ahead. We'll see what is to be done.
Subject to your lordship, kindly watch it.
No, no, no. Madam, no adjournment. What is the urgency in seeking adjournment at one?
I'm sorry, lordship, I need to move a lunch motion, lordship. I may be permitted to move lunch motion matter with regard to TSPC is conducting examination tomorrow, lordship. The petition got debarred, lordship.
2:30. I'll make a mention. Don't grant for. second court? Why?
Because Lordship,
What order has been passed?
no orders, my lord. It's a fresh admission, your lordship. We're challenging the provisions, your lordship.
Provision, no, so it was listed before DB2. So what order was passed by division bench 2?
They ordered that post before appropriate bench, your lordship. So the lordship has the roster, your lordship, to deal the case.
Tomorrow?
So please.
But where were you at 10:30? Acha, you could not mention, right? Yes, madam. What did you do the whole day? 140 you are mentioning. What? Please tell us. What you have filed a petition.
Yes, Lordship.
So what is happening?
It will be on 31st Court, Lordship. Honorable Justice Madhavi Devi, Madam. Matter pertains to service matter, Lordship. The roster with
No, tomorrow, madam. This is don't.
Lordship, there is urgency in this matter, Lordship. Tomorrow is
No, this not our roster, right?
Lordship.
You make the mention before the bench concern tomorrow.
The circular, Lordship, on Wednesday. That
No, so you will wait for the whole week and make a mention. This we will not permit.
Lordship, yesterday itself, the petitioner came to know that they are the TSPSCs debarred the petitioners from writing the written examination. Lordship,
Madam, mention it tomorrow morning.
Lordship, tomorrow is the examination, Lordship.
What examination?
To the post of assistant executive engineer and municipal assistant executive engineer, Lordship, and technical assistant, Lordship.
So what will happen if the examination, you want that it should not be held?
Lordship, I'm not saying it should not be held, Lordship. The petitioners are debarred on the ground of their alleged involvement in a TSPSC paper leakage case, Lordship. It is under the...
No, madam, we somehow we don't approve of this thing. We can't deal with anybody else's roster. You can apply tomorrow. Then the court has power to direct fresh examination for you in case you succeed. Why to install everybody that no examination should be held because criminal case is pending against me?
The petitioner can permit them to...
No, madam.
Written examination.
This thing, you at 240, 140, you are making a mention. There's no point here.
In the morning also I came, Lordship, due to the circular I thought of to mention at 1:30.
No, that is now, it is being modified. 10:30 only, this is not this thing. 10:30 only mentioning time. All the time, day, everywhere mentioning 2:30, 4:30. Any time you can mention, it's not, it will be, we are modifying that circular today. It came to my notice only 2 weeks back. We are modifying the circular, the mentioning will be permitted only at 10:30. We can't do anything about it. It's not that you are being, madam, it's not that 10:30 PM in the night you are being hanged so you can never come back to this world. It's nothing like that. We would have heard otherwise the petition till 9 o'clock and should have pronounced the order without going home. If there was a threat of execution like you are being hanged, nothing happens.
Only I am seeking to participate in the written examination conducted by tomorrow, Lordship, TSPSC. In the similar matter, also this Honorable Court granted, Lordship.
You can make a request tomorrow before the learned single judge. The examination was not fixed today, right? When it was fixed? When it was fixed, tell us which date. If you are insisting, that's why we are answering. We did not want to get into unproductive argument. Our job is not to convince you. When you are when you tell us, when was this thing? When was the examination announced? Which date? When did you file the writ petition?
Today itself we filed, Lordship.
No.
Today we filed in the morning.
Filed today?
Yes.
Alright. Where? Today means what? 18/12. 18/10. Today petition filed.
The web note in the...
1 minute. When was the notification issued for examination?
Lordship, the notification with regard to 1998, Lordship.
No, date we are asking. See, madam, it can't be that today the notification has been issued that tomorrow examination will be held. We are trying to ascertain your conduct. How much we...
22 notification was issued, Lordship. 12/9/2022.
12/9/22. Notification for?
It's a group 2 examination, Lordship, for the various posts, including the...
No. When was the interview fixed, madam? Interview.
It's a written examination, Lordship, going to be conducted tomorrow, Lordship. There is a difference in the written examination for the written post, Lordship.
Madam, any employment agency or anybody will notify the examination when it was notified. Today it is notified that tomorrow examination will be held, or when it was notified, date.
It was notified 1 month back, Lordship, but
When 1 month back, there has to be a date. When?
on 9/1/2023.
Huh?
9/19/2023, Lordship.
1923 exam notified. Exam for what?
For Assistant Executive Engineer, Lordship, and Municipal Assistant Executive Engineer.
Assistant Executive Engineer of which department?
It's a various department, Lordship, PR department and.
Right. So it was notified to be held on
that examination is going to be conducted
tomorrow, 1910. So this on 1/9, that means 6 weeks ago, it was notified that.
There is a.
1 minute. You are not arguing the case. We are only ascertaining the urgency, madam. So 6 weeks back, the examination, it was notified that it will be held on 19/2. You were waiting all along, and today you have filed a petition. Fine.
Show cause notice issued to the petitioners to submit.
We don't know what is show cause notice. We are not hearing this. Not the case that anything filed before us at the mention stage we can decide. What do you think? We are granting you permission to this thing. This all is on a mention memo, and this will be part of the order sheet in your case. Right now, which WP number? No WP number. What is your name?
It is still in SR.
What is your number? Name, sorry. Name. What is your name, madam?
P. Kavita, Lordship.
Learned counsel for the petitioner.
In appearing the examination, for that we are questioning lordship before the.
No, we are not approving of your conduct. The examination was notified on 1/9/23. You waited for 6 long weeks and have come only today. What prevented? Fine. Fine. You tell it before we will think of this thing and no mentioning at 1:30 and 2:30. We will modify the circular to date itself. You tell Mr. Rao, there is a ready. Registrar Judicial, modify this. No 1:30 and 2:30. Yes. Yes.
This matter may be taken up tomorrow.
Tomorrow?
Tomorrow. Papers were already served, but I was not intimated about moving a lunch.
Learned Mr. Prabhakar, Law Guarantee Counsel for the University on advance notice prays for short accommodation to enable him to seek instructions.
Covered matter, my lordship. Similar order may be page number 59 to 63, my lordship.
63?
59 to 63, my lordship. Similar order, my lordship.
59?
59 to 63, page number.
59 to 63.
No, lordship, it's not covered. Lordship, please.
Oh. Hare, mister. Hey, don't, I mean, we rely on you. Don't break that trust, mister.
No.
Lord, my friend is seeking Lord counseling. Lord PG admissions, Lord. Management quota 1, 2, and 3, Lord. Please stay vacancy. Lord, the university conducted.
What he wants?
For consideration, Lord. Lord, the
PG course.
PG course.
Ah.
PG course counseling, management quota counseling, as well as competent authority quota counseling, up to third round mop up, and stay vacancy also over, and allotments were given to join up 4 p.m. on the 20th October.
So, no
counseling is there, no counseling is there.
In this writ petition, the petitioner Mr. Rao.
Blood BDS will consider. Consider that
Page 25.
25 certified copy today. Yes. Which page?
Same. Lordship was pleased to dismiss the request.
Dismiss. Item 4, same order.
Same.
Item 2, dismissed. All right. You have missed the bus. So you ask your client to prepare, study well, so that this coming to stray round does not arise, and first round itself is allotted a seat, right? He or she. Correct? Ukraine students. All. Yes. Mister, what do you say? So we have decided that we'll take it up on 30th October with the condition that no further adjournment in any case, right? On any ground, including non-availability of councils. Where is that order? No, but if you but taking advantage of that situation only, he is raising an objection. Now we have to decide.
Not it cannot be clubbed to because Supreme Court judgment is only confirmed.
No, Mr. C.
It should not be alienated.
Now last 2 days, 1 minute.
This judgment was not.
1 minute. Listen to us. Last 2 days we don't want to reserve any matter. Like we will pass an order which can be decided here only. So we don't want to reserve any matter. That's why we have decided to give a date on 30th and Mr. Clear stipulation, no adjournment on any this thing ground. That he is not well this year. That is not available. No, we will decide it on 30th. No, before proceeding further, we will have to take a call on this because he is saying that it can be heard. Your stand is it can't be heard.
Yes, my lord. Yes, my lord.
We will, Mr. You will first, your first submission will be that adjourn these matters. He is opposing. So either one thing can be, one thing can be. Huh? So like 32 via media, one thing can be that we decide whether to defer the hearing or to proceed today and then hear on 30th.
Yes,
that can be done. You argue why it should be stayed. Yes.
Yes.
You.
32.
No. We are not deciding it today, Mr. We are only taking up the question whether in view of the, so that it cannot be said that orally it was said that it will be deferred or heard. We don't want. So there should be a record.
We are the party to prepare. Then it's brought to notice that on the status part.
Please point out that we don't want that situation that after I am not here, you will say that orally I told that we can't hear, we will not hear, and then nobody.
No, my lord. It was only noted by the Chief Judge, my lord, the then Chief Judge, my lord, that pendants of the writ petitions are there, full bench judgment is there, my lord. Pendency of it. No.
So both of you then file affidavit. What was, if you were present, what was said by Chief Justice? We will send it in a seal cover to Benny and invite for his lordship's comment and then decide. We are ready to decide this issue, right?
32 items, my lord. I will not.
We don't know, Mr. He is opposing. We will have to hear. No, and you said that each and every case has to be taken up. We are taking up to find out whether. Mr. We hope that we are clear, right? You want hearing to have case today? Go ahead. No. Unfortunately, there is no presumption. It would have been the best thing. The presumption is that the petition and the appeals are dismissed. Presumption. We could. Thereby, we want to record it each, and you said each case has to be seen. We are ready to take up each case to decide whether it should be heard or not heard. We will pass an order, so nobody says that it was orally said and not said, whatever. Which case? Item? We don't have slightest idea. This is a final hearing matter, Mr. Unfortunately, we have to rely on you for assistance.
In item number 28, I am ready to argue the matter, my lord. In item 28, my lord, which are also under the batch, my lord. 28, 29, 30, 31, 4 matters related to one particular subject property, my lord.
Yes, wherein I am appearing. Wherein I am appearing.
28.
28 to 31, my lord. 4 matters are related to Very same property.
Same subject properties.
You are ready?
Also same.
Yes, I am ready in 28. Item number 28, I am ready. 28, 29.
And what about 30 and 31? Not ready.
Today, advocate requested me to take that. With regard to those cases, with, 28, 29 is concerned, I am ready for that.
Can you not understand what the issue is common? No, why we are not taking up the cases finally. We are deciding the case to find out whether it can be notwithstanding judgment of full bench. It can be heard. That we are trying to. He said each and every case has to be examined. We are doing that. He says I am ready. So your case will be called. Then you say we are first calling scope of inquiry. Mister, have you understood? What is the present day's proceeding? So that submission cannot be made that orally somebody said that it will not be heard till Supreme Court is decide. We want to put that issue at rest. He said that each and every case has to be seen. So item number 23 has been called. He appears in 28 and 29, says ready to argue.
Not in
It's
my
on
cases.
your inaction, they are jumping.
No,
It's the item 23 is your case.
yeah, item 23, 32 and 33 are my cases. That case.
Well, he said one by one it has to be taken. Right?
But because senior has said it, it has to be taken one by one. Just a
That's,
of it.
we are going, he is an officer of the courts. He has given suggestion. No, Mr. Senior Counsel, we are telling you, we are deciding this question whether your submission that it can't be touched because matter is pending before Supreme Court or it should be heard. That we will decide today. You said that this question has to be independently decided in each and every case.
But the superintendent matter is that the full bench judgment is pending before everyone is getting a full bench judgment one way or other.
No, but they are not. He's saying that I am ready to argue. It has nothing to do full bench. Your colleague, Mr. He is the one.
Yes, Milad.
He and these councils, they are saying we have nothing to do with full bench. We are ready to argue.
Yes.
They are not relying on full bench. And their stand is we are deciding taking up this issue only because of their stand. Or we can do it on 30th. Choice is it.
For respondent. 23, it matters for that to full bench. They matter for not that to full bench. Therefore, they are saying they are not concerned. It matters for that to full bench. Matters not to Supreme Court.
Similar, but against the orders.
At least on this issue, there jointly you should be able to say, Mr. What is this? Like half an hour we are spending on this only.
Reference is arising out of these three cases.
Item number
24 and 25 are the state appeals with respect to a particular property.
No, 23 is what? This is different.
23 is
also before Supreme Court. 23.
This was also referred to the full bench minutes. Item 23 is also referred to.
No. So SLP is pending in respect of this subject matter.
Yes.
So it should be deferred. Where is the order in SLP?
Minutes have passed.
So we will then de-link it and defer. We will see. Because they want their case to be heard, we will see what is there. De-link. So in their case is different order, your case different order. No, but we will like to examine whether in their case also.
Respect to
23, 24, 25. Who appears for, you appear for appellant?
Respondent. 23.
You are appearing for appellant
23.
and he is appearing for appellant.
I am only in 23. 23, I am appellant, I am respondent.
24, 25 state is in appeal matters.
23, Mr. So and so, mark 23, Mr. So. So the decision on the remaining cases will have no bearing on your case, right? Okay. We also don't know. Yes. Huh? No, no. Oh, 20, no, their case. 26, 27, 28, 29, 30, 31.
I'm one
minute. 26 you are appearing?
No,
So 26 is being called. Paul, because each case has to be taken up separately, no? 26. Give. What recall? We will dismiss this recall also. Nobody is appearing.
Respondents are there. It's saying the tribunal.
24 and 35.
No, no.
Right.
20,
24 and 35, I'm appearing, my lord.
no, 26 has been called. Are you appearing in 26? 26, Mr. Chaudhary. 26. 1 minute. 26, madam. What? It has been dismissed, right? Recall application has been filed. Huh?
Yes,
when it was dismissed?
11.
Huh?
Petition is there.
No, when it was dismissed?
2014.
Dismissed. Huh? What we... Seventeen 914. 17/9. Seventeen 9. Where is 17/9/14? Office is direct. 17 850. 850. No, there has to be an order here, no order sheet.
Recall of the reference. Recall of the clubbing order.
Clubbing order?
Yes.
Which order? Where is that order?
Page 94, my lord.
17/9/14.
Yes, my lord. It's an 17/9/2014. It's an order to club along with the other petitions.
Not in this.
Page 94.
Page?
94. 94.
There is no 94, Mr. It's 65 only. What is running index?
The recall petition.
Recall petition. Where is the recall?
2018 IA.
Page 50, Mr. You are telling 94.
IA 11 of 2018.
Page 50.
50.
So what do you say?
It's been clubbed with item 23.
No. What is it covered? Not covered. Nobody, petitioner is not bothered. What to do?
They have challenged the ORC granted in favor of the respondents.
Okay, what do you say, Mr.? It's an application for this thing, recall of the order.
It will have it will have a bearing, my lord, because admittedly even the petitioners here are also not the original inamdats. They are the purchasers.
None for the petitioner. And right is presence. it appears that the petitioner is not interested in prosecuting. Same order. Same order.
Material losses.
So this Mr. Full Bench is not involved in these cases, right?
Okay, good. Because the full bench rightly law laid down holding that the subsequent purchasers from the Namdars without any, if there is annulation without any wars, such a sale is invalid and they come.
At the end of it, Mr. You have not done anything. We have to make notes and find out the facts.
Yes, madam.
And then at the end of it, we should not be told that it can't be heard.
Yes.
Mr. We are relying on you to, that it can be decided.
I am for the appellant.
We will record, we will record that this can be heard without this thing. It is not subject matter of SLP, right? Nothing to do with full bench and SLP, correct?
Matter is but order challenged by different persons. As a matter of fact, the full bench overrules the judgment passed by this honorable court with regard to this properties. This earlier.
No, Mr. This property, don't go by property number, that the full bench relates to 114 and my property is 118. Don't, I mean, this interpretation will not help you, because eventually what is the precedent is the ratio laid down by full bench, not survey number. That full bench will relate to 114 only, my property is 118. Understand, right? The legal principle binds, not the property number. That full bench is 114, therefore it will not apply to my survey, which is 100. We are giving an illustration. You understand, right?
Understood.
He's also saying that nothing. Correct, Mr. There is nothing to do with full bench or SLP, right?
Actually, this is the second round of litigation.
No, whatever. It may be 15th round of litigation. We are asking you again, because we will have to note down. You are not giving any synopsis. We will have to note down the facts. So therefore, we are asking. So none of you are not relying on any full bench decision and no SLP, right? You are arguing on the facts of the
because these appellants not file anything else, challenging the order passed by the full bench of this honorable court. They have no idea also with regard to that effect.
No idea, may not have any idea, but the law laid down by full bench will bind them. Please understand.
That is rightly laid down, Millard.
So then he is placing reliance on full bench, Mr. And you are saying it has nothing to do. You understand, right, Mr. Counsel? Please, again we are making this thing ourselves clear. We are ready to hear. But see, you don't say that full bench relates to survey number 114. My survey is 118. Therefore, law laid down by full bench will not apply to my case. Don't try to distinguish, like legal principle will bind any survey number 118 or 215. It will apply. We don't know. Let's see. So-
Otherwise, may not, at the very next day, open day, may not, your lordship will post it.
No, whatever he is ready to argue, we will hear.
Because there are 4 matters not regarding this.
Oh.
Only 2 matters regarding this.
Similar matters, similar point is involved in other 2 matters also same. 28, 29, 30, 31, my lord. In 28, 29, I am ready, my lord.
What happens to 13 and 31? They are dismissed for default, right?
No, today already councillor also Srinivas Kapati also requested me to represent matter.
No, that's all right, but you are not appearing in 30 and 31.
No, my lord, I am not.
So therefore, they will be dismissed, Mr.
No, my lord.
For default.
And
28, 29, he is appearing.
My lord, who requested me to personal inconvenience, he is unable to come. Anyway, matter is same, my lord. In this case and in those cases, point is same. Continue the same orders, my lord, common order.
Persons are different.
Person is different, common order is same.
Subject matter is same.
We don't know, Mr.
Subject to lordship, any.
We will decide. We will dictate here only. Let them argue. Then Mr. Don't seek an adjournment later on, right? We will go ahead. On your insistence, we are hearing the case today. Otherwise, we had offered, but go ahead. If you feel like arguing, you argue. We will decide it right now. We are not going to reserve the judgment. That we made it clear in the beginning itself.
Yes,
go ahead. Whatever is against you will be this thing.
Yes, ma'am. This writ appeal is filed, my lord, challenging the order dated 10/6/2016, passed by the London Civil Judge, my lord, in public pen number 21873 of 2007, my lord.
This sort of an order should never be written. One paragraph running into 2 pages. See, para 18 starts here and then continues. One para is 4 pages. It is plan for limitation. It cannot be out there without condemnation. That is the point. And 26. There was a delay of 10 years. No application to condone the delay. It's not from which provision this appeal is filed. This is section what 71 of it. Or passport pass 71 act. Pattedar Passbook Act. Yes. Madam, 1971 Act. Pattedar Passbook Act. This is the order passed under Pattedar Passbook Act by the appellate authority.
As a matter of fact, as a matter of fact, Millard, on 22/6/1991.
And we are asking which provision the order has been passed by Joint Collector.
Yes. Under
which act?
Under the provisions of the Telangana Area Abolition of Finance Act 1975, Millard.
Appeal.
Yes.
What is the provision for
Section
what is
24.
24 of
Section 24. Inams Abolition Act.
Inams Abolition Act. One. Inams Abolition Act
1955.
1955.
Section 24, subclass 1, Millard.
Section 24. Which act? 1956?
55 Act. 55, Millard. The AP Telangana Area Abolition of Finance Act 1955. Appeal filed under section 24, subclass 1, Millard.
24. So limitation is 30 days.
Yes, Millard.
You have filed it after 10 years.
That can
without seeking condonation of delay. How it could have been allowed?
Yes, Millard. Actually, as a matter of fact, Millard, the subject land is Inam land, Millard.
Whatever land.
Yeah.
The question is,
yes, Millard.
It was filed after an inordinate delay of 10 years without even seeking condonation of delay. How it could have been allowed by the Joint Collector?
Yes, my lord. As a matter of fact, my lord, there was no notice to the appellants because while passing the order by the Inam Tribunal, that is respond number 2 here in my lord, there was no notice issued to the appellants, my lord. And according to Article 123 of the Limitation Act, my lord, from the date of knowledge within a period of 30 days, we have filed appeal before the respondent joint collector, my lord.
Therefore, please read section 24(1).
Yes. 24(1) may I read, my lord? Appeals from orders under section 10 to prescribed authority. Any person aggrieved by a decision of the collector under section 10 may, within 30 days from the date of decision or such further time as the prescribed authority may for sufficient cause allow, appeal to the prescribed authority and its decision shall be final. In this case, my lord,
It does not say 30 days from date of knowledge. It says 30 date from the date of decision. If it was an order passed ex parte behind your back without hearing, you are to have filed an application seeking condonation delay. That till date I was not aware about this appeal, and therefore when I came to know within 30 days from date of knowledge, I am filing this appeal. Therefore, there is a sufficient cause to condone the delay of 10 years in filing the appeal. And then we would have understood that, but in the absence of any application seeking condonation delay.
Yes, my lord. As a matter of fact, my lord, on 7/2/2006, my lord, petitioners filed an application for certified copy of the same before the Inam Tribunal, my lord, and that was granted. That was furnished on 18/2/2006, my lord, and thereafter on 6/3/2006 they have filed appeal before the joint collector within a period of 30 days from the date of knowledge, my lord. To satisfy lordship on the point of limitation, my lord, this honorable court also entertained so many appeals.
What is the law laid down? We are concerned with law. Entertain means we don't know.
In the
This
sim-
court
in the
has
similar case also, my lord.
entertained appeal means under we are not this thing. 24 appeal does not lie to High Court. It lies to joint collector.
Yes, sir. Before joint collector, we have filed.
Then you are saying that this court has accepted appeal.
So in the similar case, my lord, when there was appeal filed before joint collector, in the similar matters, after
You mean to say that this section 24 says that 30 days from date of knowledge? What is the submission?
my lord, the petition appellate before your lordship were not issued in notice. They were not parties, my lord.
No. So one minute.
They purchased of the subject land and they are in position. In their behind their back, there was a proceedings issued by the my lord. Because of that reason, my lord, and after got the favorable orders.
No. So when you learnt, when was the order passed?
Yes. Order date, my lord.
Against which you filed an appeal.
Yes. Order date 11/7/1996, my lord.
Passed by whom?
By the Inam Tribunal, that is respondent number.
So when did you purchase the property?
My lord. Yes, my lord. In the year, my lord, 96, my lord.
No, order was passed by Inam's tribunal.
Yes, my lord. On 22, Inam Tribunal passed the order, my lord, on
11/7 you told us.
11/7/96, my lord. There is a sale transaction place. As a matter of fact, I want to bring to lordship with regard to facts, my lord. Then
No, we will hear the facts plus please answer this query first, then we will hear everything.
Yes.
So all.
Sale transaction, my lord, taken place, my lord, in the year. That is sale date filed, my lord. Mistake. Sale date 18/84/96, my lord, which is filed at page number 150 to 161. It is a false to sale.
1 minute. You just give us these dates. The order was passed by Enams Tribunal on 11/7/96, right?
Yes, ma'am.
When you purchased the property?
The appellant's predecessor in title, my lord.
No, when you purchased, you are saying I am purchaser of property. When did you purchase?
Yes, which is filed as page number 161, date
No.
is 12 May 2005.
You have purchased.
Yes, my lord.
Appellants have purchased.
Yes, my lord.
So how you can be given notice in 96, Mister?
Even there was no notice to my.
We don't know. It is for your predecessor. How can you are saying that the order has been passed without notice? Supposing if you had no interest in 96, how can the appellate this thing competent Enams Tribunal is not an astrologer who could have predicted that after passing of the order 9 years thereafter you will purchase the property, therefore he should notice to you. Fine. So you purchased. Then what did you do?
Yes, ma'am. Thereafter there was a.
No, what did you do after purchasing 12/5/2005? Then when did you come to know about the order passed by Enams Tribunal? You told a date.
7/2/2006, my lord.
7/2/2006.
Yes.
Came to know. 1 minute. Came to know about order of tribunal. Then you applied for a copy.
Hence, we have filed application on the same day. When? On 18/2/2006, that was furnished to the appellant's hearing, my lord.
Then when did you file the appeal?
On 6/3/2006, appeal has been filed.
No condemnation of delay.
No condemnation delay, my lord. With leave petition we have filed because they are third parties, they were not parties, hence they filed leave petition, my lord, taking permission to challenge the appeal.
What is the position of law? That we want to know the position of law from you if an appeal is filed beyond period of limitation.
Yes.
And so two things. Number one is please answer. We will go into all dates, like facts, etc. But please answer two propositions. Whether a delay in filing the appeal can be condoned without an application. Number one. And secondly, if an application is barred by limitation without condonation of delay, the same can be heard and decided on merits.
So far as satisfaction on the point of limitation concerned, I want
satisfaction. Whose satisfaction?
It's honorable court satisfaction, lord.
On satisfaction, we have
legal point, lord.
Query. We have raised two queries. Answer that.
Legal point.
Have we asked illegal points? You are saying legal points. Are our questions illegal?
I would like to bring.
No, tell us. Illegal.
No.
Question. Then please.
This court is there to set the things in a proper way, Miller. This court is here to set the things in a proper way.
Proper way.
And to see the things whether going properly or not.
No, we want to streamline the proceeding also and argument also so that we reach a correct conclusion. See, very often, if you ask yourself correct questions, you will get correct answer. If you ask yourself wrong answers, wrong questions, you will get wrong answers. Simple. So, therefore, the proposition number one is whether an application, whether delay in filing the appeal can be condoned. It was not condoned in your case.
There is no petition filed. Because there is no petition filed seeking condonation of delay, because you are not made as a party.
You are saying that an appeal can be decided on merits without condonation of delay. This is the argument. Any case law.
Because there was no notice to the predecessor in title on
there can't be any notice, mister. You have purchased the property in 2005.
Yes, ma'am.
The order was passed by Enams. You know that, mister. Why do you want us to repeat? You have told us the order was passed by Enams Tribunal in 96. After that order was passed, you have purchased the property in 2005. You should have seen whether or not there is any order.
It is not the case of the contesting respondent before the learned joint collector that there was a notice to the vendors of these appellants. It is not their case. that was issued at their instance.
Even if there was, Mr. Even if there was no notice to your vendors, who can make a complaint about this? You. That no notice was issued, therefore I will file an appeal after 10 years without seeking condonation delay.
Under the guise
This is the argument.
No, my lord, under the guise of these orders, my lord, there was they interfered with the position of the position of the appellants, my lord. And they filed also criminal case in CC number 351/2007.
This can't be done. By 10 years can't be condoned without. There is a special tribunal. Ask him. Ask him.
You have the joint collector proceedings dated 10/7/2007, which you have filed at page 81. Please see the last, the direction. Page 85 is the direction.
Right.
Fourth para.
Therefore, the impugned proceedings of preventive officer, Chevrolet Division in case number L/4209 94 dated 11/7/96 hereby set, and the parties are directed to approach special tribunal for appropriate remedy.
What is the special tribunal here?
Special tribunal, if there is success are there as on date of the 1/11/73, special tribunal is jurisdiction to decide the rights of the parties. And this order is
No, you were a party to it. You also purchased. See, you are the subsequent purchaser.
Yes, my lord.
So this order also applies to you.
Yes, upon the appeal filed by these appellants only, this order passed.
We say the parties. Parties includes all. See the parties which are filed at page 81. All parties, respondent 1 to 10.
Yes, my lord. Instead of approaching the special tribunal, they approach this honorable court and filed writ petition, my lord. And this honorable court passes status quo order until the disposal of the writ petition until passing of the impugned orders.
This is the impugned order. So, Mr. What, like a delay of 10 years in filing the appeal can be condoned without filing an application and can be decided on merits. This is the submission, right?
My submission is that, my lord, we are interested parties and we are in position, my lord. And
no, we are on the question of delay of 10 years. So, according to you, delay can be condoned without filing an application, without condoning, and the appellate authority can decide the appeal on merits straightway.
This honorable court decided law holding in this civil.
Which law?
TRP number.
That no delay is, no application is necessary.
In this case, said that from the date of knowledge, appeal can be filed challenging the order of.
Which order? This is single bench order.
It is confirmed by Supreme Court.
Confirmed that delay is not necessary.
Order of this honorable court challenged before Supreme Court. Supreme Court confirmed the order passed.
No, but you, without telling us what is been held in this court, you are.
This order of this honorable court confirmed.
What has been held? Which paragraph? That you should tell us, no? Without telling this, we will place it that he has not said anything, passed on the covenant and said that it has been affirmed by Supreme Court.
Relevant para is Millard, para number 25 Millard, page number 7 Millard.
20.
In first judgment Millard. Page number 7, para number, sorry, may I read Millard?
Hmm. This is what has been held in that case. So what is the judgment? Single judge, what has he held?
Conclusion is there, my lord, in page number 63. I would like to draw your last attention at page number, para number 63, my lord, page number 18. Para number 63, my lord. May I read, my lord?
Yes, we have read it.
Yes, ma'am. Yes, this honorable also clearly laid down that, my lord, the limitation for challenge said order would commence only from the date of knowledge of the order and not from the date of the said order, my lord. And next in para number 64, my lord, referring the Supreme Court judgment, this court said that, declared that an official order takes effect only when it is served on the person affected, my lord. In this case, my lord, there was a sale transaction taken place, my lord, prior to passing the order by the respondent number 2, my lord, and thereafter, my lord, in the year 2005, they have sold the property to the appellants, my lord. Since then, they are in position. And when there was an interference made by the contesting respondents here in my lord, they got knowledge about this thing, my lord, and immediately they have filed appeal before the authority according to Article 121 of the Limitation Act, my lord. And the order passed by this honorable court also appealed by the Supreme Court, my lord, for which I have already submitted judgments.
No, but see, Mr. You are not a party in this thing before the tribunal. Therefore, this does not apply to you. This applies to a person who is a party to the appeal whom the copy has not been served.
In that case
this
also,
thing, the 96, you are nowhere in the scene. Where is the question of granting you? You have purchased in 2005.
The appellant's vendor was in position.
Appellate authority, any authority in non-tribunal could not have issued notice to you in the year 96.
Yes. By that time, vendors of the appellants were there, my lord, they are in position, consultant houses, my lord, but there was no notice issued to them while passing the order by the Inam Tribunal, my lord.
No. So therefore, your vendors could have filed an appeal from the date of knowledge.
Because there was no notice to them also, they clearly sold property, getting that title free. They are having title, marketable title. Believing their version, they purchase property, my lord. Hence, well, with the leave of the leave petition only we have filed appeal, my lord. Leave also granted by the respondent number 1 here, my lord. Moreover, my lord, the precisation title of the appellant is the Inamdar, my lord. Being Inamdar, my lord, he got the ORC, my lord. Afterwards, he sold the property, my lord, developed into class and sold the property, my lord. The case of the contesting respondents, that, my lord, they have purchased property under agreement of sale, my lord. Clear agreement of sale was already declared by the full bench of the honorable court that based on the agreement of sale, they cannot apply for ORC because there was no ORC granted to
bench? What full bench? So we have understood, like predecessor in title were not given the notice of by the tribunal, therefore you can file appeal at any time.
Anytime means after got the knowledge only we have filed.
Knowledge within 30
It
days.
is not the case that there was a notice to these appellants prior to any other date. There was a notice to these appellants pre-certain title. It is not their case before even joint collector also, Miller. So for non-filing of the condemnation delay petition, Miller, there was no knowledge. According to Article 123 of the Limitation Act only, they filed petition within 30 days from the judgment knowledge, Miller. The respondents, Miller, set up the, in this case, Miller, the appellant's vendor, based on title is the original inamdar. But the claim of the contesting respondent, Miller, set up based on the agreement of sale, Miller. It is not their case that prior to selling the property, there was a ORC granted to their vendor. Because they set up the case only based on the agreement of sale that was elaborately discussed by the full bench of this Honorable Court and declared their order passed by this Honorable Court that against law.
He is there.
This is the order under the challenge before the full bench, Miller. This is the order overruled by full bench, Miller. This land pertains.
No, you said nothing to do with full bench, nothing. We will not look into anything. You argue on your first point, you have argued. What is the second issue?
Yes.
Why?
So far as
why learned single judge has erred in setting aside the order?
Yes, good. So far as the title of the title of the appellant is concerned, Miller, there was.
And now you can tell us the facts.
Yes. I would like to bring last attention at page number 141, Miller. 141.
No, facts are given here, right, in the order.
Given, Miller, this is the order, Miller. First of all, there was the order passed by the Inam Tribunal presenting the similar in favor of the vendors, Miller. The appellant's vendor. There was a ORC granted by the Inam Tribunal in the year 91, Miller, which is filed at page number 123. Start, Miller.
Read the facts from para 3 of the order. It's given, right? Single judge.
Yes,
You want to tell us the facts? It is mentioned. It was 9 acres was Inam land. Then Ghulam Moinuddin was Inamdar of the land. He sold the land.
Yes, sir.
To your father on 20th 1166.
Not father, Miller. This is the father of the respondent, contesting respondent, Miller.
It is first petitioner, respond number 1 in this appeal. Read petitioner, father of read petitioner number 1.
Yes, Miller. Now, who is the respondent number 11 here?
Whatever.
Yes.
We are referring read petitioner. Then there was an occupancy tenant. Occupancy protected tenant executed a lease deed in your favor. Right? Then 145. Then possession. It was found that 6 to 11 are in possession.
Before
and
that,
you filed this thing. Before that, filed, it was upheld up to dismissed your 10 and 11 suit filed by 10 and 11 dismissed.
We are not concerned with tenant, Miller. Our vendor is the Inamdar, one of the Inamdar, Miller, who was having off share in the survey number 91, Miller. Total extent is, Miller, 58 acres, 10 guntas, Miller. There were 2 Inamdars for there, Miller. One Inamdar, Ghulam Moinuddin, one Inamdar, Mustafa Sharif. Mustafa Sharif was granted to ORC to extent of 2 acres, Miller. Afterwards, he sold the property to the appellant's predecessor title, Miller. This is source of title. Their claim is that another Inamdar, Ghulam Moinuddin, sold the very same property under agreement of sale.
You have to give a brief synopsis with chronological list
I will
of
submit.
events. What is this we are trying to dig here and
I will permit to file synopsis, Miller. I will prepare detailed synopsis.
Because there is a long checkered history for this.
Yes, Miller.
How do you expect this court to go and see?
I am permitted to prepare synopsis, Miller.
Then why didn't you say at the beginning? You have wasted so much of time. We thought it was, it could be simple. It's not so simple. There are many complicated issues.
I will submit synopsis.
You said you were ready. We were trying to look here and there. There's no head and tail. We're not able to understand your submissions.
You will decide it just now. Let him argue whatever. You argue whatever. You see, burden is only on us to do justice. To write an order.
I will submit analysis for assistance to your answers.
No assistance. We will help ourselves. This is how you assist, right?
Because Lordship point out to furnish this for which.
No, we will not permit after 1 hour. Now you are go ahead. Whatever you have to argue, finish. You were very keen on arguing. You told us that we were adjourning the case. You said, no, I want to argue today. Argue?
Yes, please. I would like
to face the music. What is there?
Yes, I will permit to argue the matter in first to writ appeal number 798.
Yes, what are you doing? You are arguing only. Yes. We are hearing you. Now you are saying that I will argue. So what were you doing till now?
Yes.
You are arguing only. Now I will argue me that we were arguing so far, right?
Finding that facts so far position is concerned were clearly recorded by the Inam Tribunal Miller while granting the ORC Miller.
1 minute.
In its order,
1 minute, viewers. This is para 17 is the finding. This is what? This is this title. Finding of trial court concurrently upheld so and so division bench Supreme Court.
Yes.
Title of Ghulam Mohiuddin, first petitioner and his brother affirmed by all forums. This is one. We were finding against him. Second is this. Inam land, protected land in favor of the assignment of interest has been held to be illegal and void. This is second finding. You cannot comprehend the controversy also. Then the third is delay of 10 years. Yes. So that's all.
First argument filed which I would like to drive attention at page number 148. That is the first order.
Do you why the rate petition has been allowed? Do you know?
Yes, Mirat.
Why it has been?
Yes, holding that the delay was not properly explained.
Wrong.
This is one ground, Mirat.
Wrong, Mister. This is an attempt to mislead the court. Wrong.
We have properly explained delay, but that was not properly appreciated by the learned single judge, Mirat. That is
it has not
ground
been,
number 1 before Lordships, Mirat.
Ground number 1 is title of Ghulam Mohiuddin and has been this first petitioner and his brother is affirmed by forum in all civil proceeding, and your claim of declaration of title and grant of injunction has been
No, that is
dismissed.
not filed. That is different applicants. Here, Mustafa Sharif is different, Miller. Mustafa Sharif died when
This is a we are trying to tell you that you are trying to mislead the court only by saying
that is there.
No, you are trying to tell us that the petition has been allowed, the petition against me has been allowed only on the ground that there was delay. It not delay. Para 17, learned single judge has recorded reasons. We have read it, Mister. Don't do it.
Yes, before that,
Don't try to mislead the court. We will impose cost on you.
Before that, I would like to draw your last attention at finding of fact recorded by the Inam Tribunal, Miller. That is the proper authority for recording the findings, Miller. Because under the Inam Act, Miller, Tribunal constituted to decide the matter, Miller.
For declaration, we have lost up to Supreme.
Yes. Under section 10 of the Act, Miller.
Go ahead. Yes.
Under section 10 of the Act, Miller, that there is Inam Tribunal is competent to decide the rights of the parties, Miller. Section 10. Accordingly, there was inquiry conducted by the respondent number 2, Miller, passed the order in the year 1991, Miller, which is filed it. Before going to the findings, Miller, I would like to draw your last attention towards the finding of facts recorded by the Inam Tribunal, Miller, which is at Miller, page number 141, Miller. 141.
Take 3 reasons. and see his claim. Nothing, he doesn't understand. No, and this, see, this he has filed. Everything it has been dismissed. He's only listening.
Your Lordship, kindly see page number 141, Milan.
Dismissed. Declaration of title. You are sued for declaration of title and injunction has
No,
been
Milan, that is
dismissed.
not filed by vendor. That is different case, Milan.
Different case.
Because the learned singular not properly appreciated the facts. Hence, Milan, I would like to drive your last petition as the first order passed by Inam Tribunal. That is the basis, Milan. Inam Tribunal constituted that was decided the matter properly, Milan. Which is filed at page number, Milan, page number 121 to 148, Milan. Finding of fact recorded based on the revenue record, Milan, appreciating the revenue records. Finding of fact recorded, and that was also confirmed.
That is the order passed in 96 behind your back, right?
Behind my back means my vendor's vendor.
That's a vendor. Hey, what is this, Mr.? Something we are just like. Where does it show that a person who will be a prospective purchaser, he should also be given by notice by the appellate authority?
And then the date of the
or you at least to tell us that supposing if your vendor's vendor was not given any notice in any proceeding, you are entitled to raise this contention. Vendor's vendor was not given notice.
Sorry to disturb you, Lord. The very tribunal, Inam Tribunal was passed order 6 based upon the petition filed by vendor's vendor claiming. So, Lordship seen that HB number 201.
Let him.
You know, that is he's saying that
He is ready with the case, right?
Yes. Yeah. As a matter of fact, survey number 91 total extent, Milan.
So is vendor's.
No, Mr. Bande, please understand, this is not the case. This is not the way to assist the court in a matter like this. You should, in all fairness, you were insisting that it should be heard today. He was insisting it should be heard today. This is not fair. And your part, no, you said, I am ready. This be heard, nothing to do. He said that.
It should not be.
All right. Now, 1 hour has passed now. There is no point in getting into this argument. We are responsible, right? No, Mr. No. We are responsible for the situation. You are not responsible. You are just, we are forcing you to argue and you are arguing. Fine. Go ahead.
First, I would like to draw your transportation page number, Milan, 121 to 148. This is the first order passed by the Inam Tribunal, Milan. Wherein, Milan, finding of fact recorded by the Inam Tribunal, Milan, which is at page number 141.
Which order, Mr. Inam Tribunal means what? What is the order? We are concerned with only one order in 96.
Not 96, Milan. Prior to that, source of title.
We are not concerned. This petition does not relate to tracing out the source of your predecessor's title. Please understand, the scope of intra-court appeal is confined to examining the validity of the view taken by learned single judge. Before learned single judge, you had the other side had challenged the order passed by the appellate authority under section 24 that has been set aside. In this intra-court appeal, you cannot demonstrate that my vendor's vendor had this title, that title, and this is not a civil court recording a finding that you are the owner of the property. Sorry. This we can't do, we cannot look into. You read paragraph 17 for your benefit, you will know why the petition filed by other side has been allowed. If you have not read it, please read it. Then you need to meet the grounds mentioned by learned single judge in para 17 of the order why the petition filed by other side has been allowed. Sorry.
In pair number 19, Miller, the learned single judge recorded a finding that, Miller,
para 17.
Sorry, Miller, para number 43, Miller, final page. Last paragraph, 43, page number 43, Miller.
43, it's 29. What?
43. 43, fourth line, South Miller. The decision in Mudakaba's case and decision in Ravindra case laid on by counsel for the respondent is not applicable to the facts of this case. The matter is concluded by the Supreme Court by affirming the order of
no, you were which respondent in the writ petition? Respondent number?
Respond number 3 to 5 million.
3 to 5.
3 to 5.
You claim title on the basis of independent title, right?
Yes, yes.
Nothing to do with.
On the basis of the ORC granted in the year 1991 by the Inam Tribunal. Because earlier in respect of the subject property, ORC granted, after granted was the owners, Inam das developed property.
Please appreciate that we have to pass an order. You cannot pass an order, right? By now you would have given it to signed and given. If we are asking you some query, you are bound to answer. So that, I mean, we have to pass an order. If you would like say anything, then we will pass an order. Say anything. How are this 10 and 11 are concerned? You are not concerned with them.
6 to, in the case, the petition filed by the single judge. The respondent 7, 8 are the vendors.
No. This is 10 and 11. They are not concerned with you. You are not concerned with 10 and 11.
I am not concerned 10 and 11, Millard.
That's what we are asking.
Yes, Millard. We are concerned with the Millard 6 to 9, Millard.
Who are 6 to 9?
They are the sons of original Inamdar. One of the Inamdar, Millard. Mustafa Sharif.
What is the name according to you?
Mustafa Sharif, who died leaving behind respond number 6 to 9, Millard.
All right. So, what respond number 6 to 9 have sold the land?
Yes, Millard. Respond number 6 sold on their behalf. Respond number
6 to 9.
Muhammad Rahimullah Sharif sold the property, Millard.
Sold the land to you in the year 2005.
1996 to my vendors.
Who is your vendor? No, he is not there. It's not a party. No. So 6 to 9 sold the land to
different purchasers, Millard. They sold the property to the appellants.
To vendors of petitioners, and petitioners have, you are like respondent 3 to 5 have purchased in the year 2005.
Yes, Millard.
Correct.
After granted ORC in favor of the Mustafa Sharif, Millard, the respond number 6 sold the property to various purchasers, including the vendors of the appellants before your lordships. And subsequently, Millard, this order has been challenged by the contesting respondent before the joint collector. And that was wherein also appeal filed by them dismissed. And thereafter they have filed CRP before the honorable court. That CRP allowed, Millard. When CRP allowed, afterward remanded matter back to the Inam Tribunal, then ORC passed out. This is the facts of the case, Millard. From the beginning, the petitioners before the single judge, Millard, set up the case based on the agreement of sale, Millard, saying that they purchased from Ghulam Muhammad, who is half shareholder along with Mustafa Sharif. As a matter of fact, there was no ORC granted in his favor to sell the property under agreement of sale. Even though they sought for ORC before the Inam Tribunal in the year 91, Millard, and examining the matter in detail, only Inam Tribunal rejected their content, their claim for ORC. And based on the position of the Mustafa Sharif, Millard, ORC granted. As per the Panis 1973, Millard, Mustafa Sharif was in position.
Number was Ghulam. He is setting up some other person. This finding is there 70 up to Supreme Court. If he is challenging this issue, he is not a party to this proceeding. He should challenge this. Now land, what is like we decide the question of title. No, people to agree. We will make sure if they were given on tenancy, we will protect the tenants. So they used to share the ratio 60-40. It's only protect the tenants. We purchase from the original units. That's way back. But this will not purchase from Ghulam. When we purchase from builders, yes, there is no clear flow of title.
As a matter of fact, the respondents are no way concerned with the subject land, and under the agreement of sale, they are not entitled to get any rights to the property. As such, will have full range of this honorable court rightly sets aside the order passed by this honorable court, directing the RDO to
No,
issue
the
ORC
bench
to
is nothing to do with this case. We are examining the validity of order. You told us full bench has nothing to do with this.
Moreover, Millard, according to section 3, Millard, the title vested in the government, Millard. When title vested in the government, the person of selling of the even one inamdar also does not raise any part of the inam land prior to grant of ORC.
What is your right? And what is your right once it is vested in the state government? What is your right once the lands are vested with the state government?
Yes, thereafter Inam tribunal conducted inquiry and passed ORC in favor of the inamdar, Millard, that is Mustafa Sharif, to the extent of 2 acres. Thereafter, Mustafa Sharif sold the property to various purchasers. After granting ORC only, Millard, the sale transaction taken place. Was the submission before the Inam tribunal by the contesting respondent that they also purchased the very same property on agreement of sale from one of the inamdar. That was considered by the Inam tribunal. And moreover, Millard, that finding was also not considered by the accepted by the joint collector. The order is become final. Joint collector order is become final. So far, the finding of fact is concerned, Millard. Because after upsetting the record only, there was a ORC granted, confirmed. Matter there ends. Under 226 of the Constitution of India, this court also no jurisdiction to set aside the finding of fact to, unless it is vitiated by any fraud. It is not their case, Millard.
This is a new legal principle that finding of fact can be set aside only if there is a fraud. You think of asking what is the according to us the legal principle, if the finding of fact is shown to be perverse, it can be set aside. As this is a new ground that if the finding of fact is can be set aside only when it is fraud. Supposing if it is based on no evidence, then also according to you it cannot be set aside because it has not been obtained by Mr. Don't time
in the section 24 is very clear that if any question arises whether any building or land so and the prescribed authority, its decision shall be final, Millard. In the 24 section, Millard, it's very clear that appeal to the prescribed authority and that its decision shall be final.
Final means
final before the honorable court. Because all the final is recorded based on the evidence available according to the provisions of the Revenue Act, Millard. Based on the PAN's physical verification order passed by the tribunal. And not construct the claim since they set up the claim under agreement of sale. So here, the case with Mustafa Sharif being inamdar, got the ORC, put up the land, sold the land. When this purchase and provision, there was no, they filed appeals behind that and got the favorable orders. Hence, when they got married, they charged the land. And they are in position, considered how this spending lakhs of rupees, they purchased the properties and in the position of the same land.
They only lakhs, not crores of rupees. Only lakhs. They should have spent crores of rupees. Why lakhs? What else? That's it.
But first of all, they are deriving the title from the product lot in numbers. Number 150. They are claiming the title from the.
So according to the petitioner, learned single is narrated or irrelevant facts.
Just Milord.
That's what is argued.
Milord, before the Milord, you have seen that Milord, before the criminal order dated, 1996, Milord. Yeah,
No, you are appearing for whom?
Item number 29, Milord.
No, not which case? 796. Item 28.
9, Milord.
No, 28. not appearing. Then he is arguing 28. We have taken up.
Same subject matter, Milord.
But how come, Mr.
Same subject matter. I am saying that I am 29, Milord, item.
So you argue when 29 is called. Presently 28 is being taken up. Yes, Mr. What do you say? He doesn't know. Like, and he's saying I'm arguing. So this is not appearing. No.
The statutory authority cannot extend the period of limitation not until unless there is a controlled delay application. Even
No,
if
but
there is no
this thing, there is a view taken by learned single of this court relying on Supreme Court. They have put a purposive construction on this expression and said that it should be construed to mean date of knowledge. That is that.
even for considering the date of knowledge, my lord, there should be an application.
No, but it is from date of knowledge, it is within limitation, 30 days, it has been filed. It is not barred by limitation. What about merits of the case?
Even otherwise, my lord.
See, Mr. He gave an impression that as if he's appearing an entire bunch and not like.
But the primary.
And he did not even, all along, my brother asked whether who is appearing for respondent. I told him that he is appearing for respondent. Now he says I am not appearing. This is what.
29.
This,
28, 29, 30.
you have to be at all times, Mr. Irrespective of decision of a case, you have to be fair to the court because we rely on you.
Just records in that showing that I only appearing in.
No, so you should have, when he was arguing, you should have said, sir, I am not appearing in his case. So those means he doesn't write an order. Shall we give him? You comply with the whatever order he passes. Whether he knows means what? Court should not know, your brother should know. That's it. Not fair. We rely on you. Don't do it again. At the beginning when we were asking him to, he was saying, I am ready and I will argue. You should have said that, sir, I am not appearing in 28.
Just because I said that, he said that there are both back matters, same subject matter.
Did he say, brother?
I'm only appearing in 29, not 29 item.
You should have, you owe a duty. My brother also remembers you did not say anything. Because he asked me that nobody is appearing in 28. I said he is appearing. What? Unnecessary. Who will write judgment, mister? You are forcing us in a case in which you are not appearing. We said that we would not like to reserve a matter. We would pass orders on bias only. You are forcing us to decide a case in which you are not even appearing. Please sit down. Please sit down. We don't want to say anything to you.
Lord, the primary tribunal, Lord, initially granted ORC.
Mister, what is it?
Lord, the primary tribunal granted ORC in favor of the unofficial respondent.
There is nobody to oppose the prayer in this rate appeal. Nobody appears.
Yes, no, the relief was granted by the joint collector in favor of the respondent appellant's hearing now. Lord, challenging which the writ petition.
Why have you stood up? Sit down.
But the writ petitions are not here, not were challenging the order of the.
What to do? We are deciding now after 1.5 hours we can't adjourn. So what is it? That appears to be, the construction appears to be correct. By learned single judge placing reliance that it has to be construed within 30. So appeal was within limitation. What about merits?
Even the other, even not.
His submission is that all irrelevant facts have been noted by learned single judge. That's what he says. That learned single judge is not understood what is his case. Like we are not understanding what is his case. Because he himself doesn't know what is his case.
It's a case to be matter to be reviewed before the single judge, not because all these facts were not there before the single judge.
What facts?
The facts with regard to the earlier ORC granted on the very same subject line. And there are joint tenancy.
Which is the previous order of Inam Tribunal? Is it here on this record of this writ appeal?
Yes, Lord. At page 123. Page 123, there are proceedings before the primary tribunal.
So what it is between whom?
Between the purchasers of the original Inam, the Ghulam Mohammeduddin and Mustafa Sharif. Both are the joint Inamdars. That's what the contention of the appellant's hearing now.
This order dated
order dated Proceedings in 86.
June 91. Right?
Yes, bro. 22nd
So
June 1991.
it is by land tribunal. What is it? Which authority?
This is also by the primary tribunal.
Enam tribunal. Enam tribunal.
Yes, bro.
What has been held?
But rejecting the claim of the respondents.
Mustafa Sharif and
respondents, bro. Respondents.
So what happened in this proceeding?
And granted occupancy rights to the petitioners 2 to 5, who are the appellants, predecessors of the appellants. And this fact has not been there before the single judgment. It has not been argued. I've gone through the single judge's order, my lord. This fact was not brought to the notice of the single judge, my lord, that they were holding the ORCs earlier on the very same subject land.
Arey, Mr. What has been done by this order dated 22/6/91 by the tribunal?
ORC was granted to the applicants therein. There was already an ORC.
Applicant Miss Mustafa Sharif.
Mustafa Sharif, die per LRs, Rahim Sharif and Karimullah Sharif and others.
Occupancy rights were granted.
Under Section 10 of the inquiry conducted, Section 9, my lord, inquiry under the Act.
Occupancy rights granted to
by the primary tribunal.
So what happened to this order?
But this fact, my lord, they are brought.
No. What happened to this order?
ORC has been granted, it's not challenged, my lord. There is no appellate order filed in this, my lord. This is the primary tribunal order granted.
This is order in favor of Mustafa Sharif.
The appellants herein now.
No, he is not relying on this order.
This has not been This has not been considered by the single judge, my lord.
Did you produce this order before single judge?
We have already filed counter also.
They have filed.
Yes, counter
Arey,
also.
Mr. They have filed.
Which is now also before your lordship, which is at page number 63 to 63.
Their pleadings have been read and para 8, my lord. Respondents 3 to 5.
Read this thing. I have to reject the claim of respondent. Do not really interfere with occupancy right, father of 2 to 5. Mustafa Sharif.
Everything brought to the notice of Lunar single judgment by filing detailed counter, my lord, which is filed at page number 63 to 67, my lord. I would like to try your petition.
You have argued, Mr. Again,
this 91 order has not been referred to, my lord, by the single judge.
No. Whether this order
has not been discussed.
1 minute. Not discussed, we have understood. Whether this order has been taken note by the additional collector.
By the joint collector.
Joint collector. If he has not taken, then we will remand.
The joint collector's order is at 2007, page 80, my lord.
No, has it been considered or not? Joint collector has considered this order.
Which order?
Which order?
Consider, my lord.
22nd June 91.
Considering that order only passed orders in favor of the.
Where is the order passed by the joint collector? Page
499
is 499. Sorry, 80 onwards, 81.
499.
The joint collector had already held that as on that date of the decision, land stood converted into the non-agricultural lands, my lord.
499. Material.
Page 84, my lord, the joint collector order.
499, my book. It's only up to 296.
I had considered the nature of the land to be non-agricultural land and said that the Enam's tribunal would not have jurisdiction, which had been found fault with a single judge saying that
Madam, there is one material paper.
the consideration of the material should be as on the date of the vesting, but not on the date of the decision.
He has got a copy 499.
796.
80 minute, page number 80. 80 minute, page number 80.
80.
80, the operative portion at page 84.
81. It's not 490.
term
All right.
The joint collector considered only in respect of the nature of the land.
One,
saying that
one,
it's a-
minute, 1 minute.
The additional collector had only considered the nature of the land as on the date of the decision. The single judge had found fault with that. The nature of the land as on the date of the vesting has to be taken into consideration, but not the date of the decision. On this ground, writ petition has been allowed. Not only delay, my lord, it's only on the order of the joint collector has taken the nature of the land as on the date of the decision. The land stood non-agricultural land. This has been found fault by the single judge, saying that you have to take the nature of the land as on the date of the vesting, that is on 1/11/73.
So all the more reason, one additional ground in their favor. The appeal has to be allowed. Though he has not been able to argue that, but the fact is that appeal has to be allowed. There is an order in his favor.
Yes.
You are saying that there is no material to show that this order has been challenged any further. What happened to this order? See, he doesn't know which order we are talking about.
But order is challenged by the respondents, Miller. Contesting respondent filed a petition before this honorable challenging the order of the joint collector, Miller. They filed a petition, and that was allowed, Miller. For which only we filed it.
That really you don't know which order we are talking about. 22/6/91.
91. That order challenged by the respondents, Miller. That was their appeal was dismissed by the joint collector.
When?
On 9/3/96, Miller.
Then what happened?
In appeal number, Miller, B3/5237 of 1991. B3/5237.
means Bombay.
Yes, Miller.
B3.
B3/5237.
5237
of 1991. That was dismissed. Their appeal was
what happened?
Appeal was dismissed, Miller, on 9/3/96.
Correct. Thereafter, what happened?
Thereafter, they have filed CRP before this honorable court.
Then what happened to CRP?
That CRP was allowed, Miller.
Allowed?
Yes, Miller.
Then?
Lord remanded the matter back to the Inam Tribunal.
Then?
That CRP number, Miller, 665 of 94.
So, when it was decided?
On 13/9/96, Miller. 13/9/96, that was allowed. And remanded the matter back to the Inam.
What happened?
Inam Tribunal, without issuing any notice to the our members, and also they decided in their favor.
This is a previous order, mister. You are what?
Well,
this is the way to assess. This order is not in existence. No, again back to square one, right? This 11/7/96 Elam Tribunal has passed an order. This is nothing. This has been set aside.
It's not there.
Yes, anything else?
Obliged.
Obliged?
Nothing else, Miller. You are asking everything. Updated.
No, but this is, we were saying that this is the order in your favor. This has been set aside. This is not in favor.
Subsequently, when matter remanded, there was no notice to us. Meanwhile, already land developed into plots and sold to position.
Mr. This after remand, it was decided when?
After decided, Miller?
Remand.
11/7/96.
So how 11/7/96?
File number L/4209 of 1994, Miller.
No, but they,
after remanded the matter by this honorable court, Miller. After remanded the matter by this honorable court, the RDO Inam Tribunal conducted inquiry, Miller, granted ORC in favor of the respondents. That was challenged by the before the lordship report joint collector.
11/7/96 is where is the order?
That is at page number 201 to 263, Miller.
201. So Mr. What do you say? 201 is nothing. 11 cell.
That ORC has been reversed by the joint collector by the computer. That ORC has been reversed under section 24.
What is written pages after pages? God only knows. 60 of the events of these pages. This their vendor has sold Muhammad Sharif, Mustafa Sharif. Has sold everything. Has achieved release 262. Has achieved release 262.
The impugned order before this court is at page 81, my lord. Leaving all these facts, my lord, only on the ground of on the basing of the report of the Tahsildar, saying that the land is a non-agricultural land, he had set aside the proceedings of the ORC, my lord, of the primary tribunal. Page 81. I refer, my lord, impugned order of the joint collector. Page 84.
That we have seen.
But ignoring all the events happened in the case, my lord, that who is in position as on 11173, merely relying upon the report of the Tahsildar, my lord, that land ceased to be an agricultural land, had set aside the ORC, for whom the rights were accrued on 11173.
This order has been set aside, right? By the
Yes, by the single judge. I agree with the contentions of the learned single judge.
So he has not, therefore he has rightly set aside.
Yes.
Yes. Anything else?
My,
Don't argue like this, right? Once we are doing it at his instance, to which he is not a party, but don't do it again. This, it's like unnecessarily troubling the court for your sins. You are not ready with the case, troubling the court, we will have to sit and dictate the order. Thank you. Thank you. This intra-court appeal. Mark his presence, none for respondents number, whatever. You appear for whom?
I appear for the draft.
Respondent 1 and 2.
One and
None for respondents 3 to 11. What? Arguments heard, judgment signed and dictated. Separate sheets. You can go, mister. We will not take up your case. It will come tomorrow. You are 29. We are now, what do you expect us? It will take about 45 minutes to dictate the order in this case. Your case can't be heard today. You can leave. It will continue tomorrow.
Same impure not in my case. Same impure not.
We don't know. Now, whatever, you are not appearing in this case. Now, we are passing an order.
Same impure not at the same delay.
No, your case will not be taken up today. Nobody need wait, Mr. Rao. Don't wait. We are only dictating the order at their instance. He said that I am ready and order has to be passed today. So we are giving him the gift. He has troubled us like without synopsis. So we are duty done. Not the way, mister. Not being fair to the court. Such cases like we have been noting, finding it out. The net result is an order against you. What can be done? He has succeeded without appearing in the case.
in this case,
This intra-court appeal is filed against an order dated 10th of June 2016 passed by learned single judge, by which the writ petition preferred by
That is by the primary tribunal RTO, Mustafa Sharif.
This thing. The 123.
3 to 10 minutes.
1 2. 22 6.
3, 4, 5. 3.
22 6.
3 to 6.
The matter.
3 to 8. 3 to 8 are the appellants.
1 minute.
'91 order.
30th. 1. The paragraph. The one Mustafa Sharif claiming to be Inamdar of the land initiated proceeding for resumption of the land. Court has relied on decisions of Supreme Court. We are not inclined to hold. What is your submission on bench?
On limitation,
He erred in setting aside, right? Learned additional whatever submitted that the has supported the order passed by the learned single judge and has submitted that the joint collector has not dealt with the various grounds. Your case is for remand. Remand.
Yes.
Has not dealt with the various grounds on which the order was passed by the Inam tribunal and has merely on the and has recorded a finding that and without assigning any reason has recorded the finding that the subject land is used for non-agricultural purposes and therefore the and therefore the learned single judge has rightly set aside the order passed by the joint collector. It is submitted that
I can only assist the court.
remand.
I appeal for the,
Prayer is for remand.
no, Lord, I appeal for the department, tribunal, both the tribunals, Lord. I appeal for the RDO and the joint collector, both.
So you are supporting the order, no? Passed by learned single judge.
But I can't take I can't take a stand, not being the authority tribunal. I can't take a stand. I'm not appealing for the parties.
Then, so what is your, if you are appealing, you have to make some submission. Otherwise, don't appear.
Yes, Lord. I am only assisting this court, not I'm not appealing for the parties.
So, Mr. What we have to record, right? Your stand. What is your stand? It should be remanded. That is the just and proper. Delete everything. Learn
The judgment of the Supreme Court.
has set aside so and so. Has only set aside by holding so and so paragraph. We have considered the So what about 29?
Don't same Milad. 20 also same Milad.
But we will have to hear him.
Obligation.
Because we told him no that we will not pass an order today.
Obligation.
Don't, Mister. This Mister should be a lesson to you. Unnecessarily, we have been required to sit till 5:30 just because. And this is the level of preparation. You have succeeded on a ground which is not even argued by you. Don't say. Do you realize this? That you have succeeded on a ground which is not even argued by you. This is not, you didn't argue that these are the grounds and this is what's cryptic manner the joint collector is allowed the appeal. Therefore, it has rightly been set aside. It should be remitted back. This you didn't argue. Not fair. You see, Mister, you have the capacity to improve. Take this, give it to me like once rough. I will.